All right, then we'll start. This is Renee Lind. I'm your Vice Chair of the Colorado Real Estate Commission. Today is June 3rd, 2025, and it is 9:03 a.m. This is a public meeting of the Colorado Real Estate Commission. We will now call this meeting to order. I'll begin by having Director Waters perform roll call.
Renee Lind.
Here.
Bernadette Bergeron.
Here.
Autumn Rubal.
Here.
Erica Saunders.
Here.
Erica Doyle.
Here.
You have a quorum.
Okay. Next, we need to approve the meeting minutes from April 1st, 2025. Can I have a motion for the approval?
Motion to approve.
Okay, was that all right? Erica Doyle, I heard, and can I get a second?
Second.
The other Erica. Okay. So I have a motion. So we've got that approved. Second is made. Any discussion on the minutes? No. Okay, so there's been a motion and a second to approve the April 1st, 2025 minutes from the Colorado Real Estate Commission. We'll now take a vote. All those in favor?
Aye.
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 Any opposed? Okay, we have, well, actually, we would have 4 since Bernadette wasn't there. So we'll have 4, the motion passes. And then next on the agenda are other matters. Does anyone on the board or commission have any other matters to discuss? And we'll also open it up to the public presentation. And David, you're going to address the CE.
Yes, thank you, commissioners. I'm going to be placing a poll on the screen for all attendees. If you are seeking to receive continuing education credit for this meeting, provided that it lasts the required duration and that you attend for that duration of time, we will issue a certificate of compliance for continuing education credits within a matter of a couple days following the end of this meeting. So with that, I'm going to place a poll on the screen. Please complete that if you are seeking credit. And with that, I'll pass it back to you, commissioners, and take that poll down after a few minutes. Thank you.
Okay, so we'll now take up hearing matters. First, we're going to discuss case 2024-0014, which is Colorado Real Estate Commission as petitioner versus Susan Alaya, license 1000828803, respondent. And oral arguments are scheduled to be heard today on the respondent's exceptions to the initial decision. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Sue Kim, Assistant Attorney General as Conflicts Counsel, with paralegal Sarah Baumgardner. And David, I guess you'll confirm audio when they're ready.
Ms. Baumgardner, I just allowed you to unmute if you will need to speak. And then Ms. Kim and Melissa are already good to go.
Okay, thank you. All right, formal charges were filed in this case. Respondent answered. The division filed a motion for summary judgment alleging that respondent had violated the broker laws, namely sections 12-10-217 1M, N, P, and W of the Colorado Revised Statutes and Commission Rule 6.23. Respondent filed a response. The administrative law judge granted the motion, made findings of fact and conclusions of law with recommendations for discipline, which are included in the initial decision. Exceptions to the initial decision have been filed by respondent. The commission as petitioner has filed a response. The commissioners have had an opportunity to review these materials. The parties have been informed that oral arguments will proceed today beginning after 9 a.m. Mountain Time. Each party will have 10 minutes to present arguments. Then the commission will deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. Okay, so for oral arguments, I will ask each party to identify themselves. We have appearance for the petitioner, Colorado Real Estate Commission, please.
Irina Groni, Attorney General's office, present.
Okay, and appearance for the respondent, licensee, Susan Alaya, please.
And Commissioner Lind, I don't know if she's been given permission to speak if she is on the meeting, so maybe we could ask her to raise her hand if she's on the meeting.
David, do you see her to give her permission?
I do not at the present time, commissioners. So Ms. Phipps's recommendation of perhaps raising your hand would be helpful. We do have a hand here. Mr. Corwin?
Yes, and I'm sorry to bother. I was trying to sign in and I don't think I signed in correctly. I only saw 2 questions of 4, so this isn't pertinent to what you guys are talking about. I apologize.
I've got you down. And any other individuals, we'll monitor that. So thank you for that, Mr. Corwin.
Okay.
But so we can step away from that. Thank you.
Madam Chair,
Yes.
just procedurally, the division had issued a notice for the oral arguments to proceed at 9 o'clock, as you have just mentioned. It is customary at times, or discretionary with you, to wait a certain amount of time. It was noticed for 9 o'clock. It is now 9:10. In my opinion, you can pass this matter and recall it at perhaps 9:15 or at a time that you choose. Or you may proceed because it is after 9 o'clock.
Have we heard anything from the respondent?
Perhaps you can pass it to Ms. Groni as a party to this matter to see if there's any further information, and or to Melissa Phipps
Okay,
as your staff contact here.
okay.
And-
Irina, have you heard anything from the respondent
No direct communication with me. I was expecting her to appear.
or Ms. Phipps? Nothing?
I have not received any communication from her either. I have in the past on unrelated matters, so I do know that she is aware of how to communicate with me, but I haven't received anything recently in regards to this matter today.
Okay, well, given that it is now 9:11, do we proceed with oral arguments on the one side?
Madam Chair, it was the respondent's request.
Okay.
Because she is not here, but it has been noticed, it would be up to you to ask if the division proceeds with any response, but because it was not their request, it would be up to them whether to have any further statements at this point.
Okay, well, seeing that it was her request and she's not here, I guess we can skip the oral arguments and we can go ahead and move on. Commissioners, you had a chance to review things. Do we need to go into executive session for anything, or are you ready to proceed to a motion or discussion?
I would be ready to proceed. I don't have a need for executive session.
Okay,
I'm ready to proceed.
all right, Autumn. Is she-
Same.
Okay, and okay. All right. Then does anyone want to have some discussion or make a motion? There were a couple items that look like they need to be addressed or possibly changed with the original motion. Does anyone want to do that? Or I can also read something.
Well, without that individual being here to present argument, I mean, I reviewed everything and really came to the conclusion that I was pretty much in agreement with the ALJ. So the only thing that was in question and for me was if we would stay the $7,500 fine until maybe, she reapplies for her license if that ever were to happen. But outside of that, I felt that what the ALJ, the discipline that the ALJ provided was actually fair and warranted.
I do agree with Erica as well. After reading all of it, I probably wouldn't do the fine either. I don't know if we'll ever get the money off of that after reading all that.
I agree that adopting the decision in its entirety would be warranted. Revocation is warranted to protect the public due to the defrauding of the investors. The ALJ agreed with the commission that the respondent violated broker law on all 3 counts. I would go ahead and make it concurrent, and because of the lack of income, stay the fines unless the respondent reapplies for licensure.
Okay, and then we had the other item of concern had to do with the 15% surcharge. Did you agree, commissioners agree that that should also be included?
I believe that should be included, but stayed with the remainder of the fine. And just want to kind of say that in reading the response, it was about her experiences and not one mention about any of the victims. So that's why I think we definitely should keep that fine. I really thought that was actually very lenient.
Okay.
In this scenario.
Erica, would you like to make a motion?
I could. Let me find the proper. I know that it's in here somewhere. Hang on. It may take me a minute to find that page.
It was on page 4.
It's on page 4? Okay, thank you. Okay. Let me find the right one. So let's adopt. Okay.
It was on the exceptions matter.
Yeah.
Page 4.
Okay. Okay. So I move to adopt the findings of fact and conclusions of law in the initial decision, but to modify and order disciplinary terms as follows. Public censure, revoke respondent's license, administrative fine in the amount of $7,500, plus mandatory statutory surcharge under paragraph 24-34-1082 CRS for a total of $8,850. Make concurrent the administrative fines for counts 1 and 3, and stay the entirety of the administrative fine pending respondent's application for a new license.
Thank you. We have a second.
Second.
Okay, Erica. All right. Okay, so now we're going to take a vote. All those in favor say aye.
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 Okay. Any opposed? All right, motion passes. Okay, so the motion for final agency order. We will invite a motion to direct Conflicts Council to draft the final agency order reflecting the commission's determination, and will delegate authority. We can delegate authority, go ahead and delegate authority to Ms. Phipps to sign the order on behalf of the commission, unless someone wants to see that again. And someone make a motion for that final agency order, and then decide if we want to see that again, or if we want to go ahead and let Ms. Phipps sign that.
Did it log you out? Oh, I hear you. What?
Erica, Autumn, Bernadette, someone?
I move to delegate staff to draft the final agency order.
Okay, and is it okay for, who do you want to sign that, or do you want to see it back?
We do not need to see that back.
Okay, and who are you delegating to sign? Can we delegate Melissa to sign?
Yes.
Okay, all right. So motion is for the final agency order with being delegated for authority with Melissa Phipps. We do not need to see it again. Anyone, was there a second?
Second.
I'm not sure who that was. I think it was Bernadette.
Yes.
Okay, all those in favor?
Aye.
Aye, and any opposed? Okay, motion carries, and we are done with the first hearing matter. Okay,
So, Madam Chair, just a
yes,
quick, just confirming that the final agency order will issue as directed by the commission, and it will be mailed to the parties by commission staff.
yep, sorry, yes.
Quite all right. And if there's nothing further on this matter, I will excuse myself at this time.
Okay, thank you.
Thank you.
Okay. All right. The next item on the agenda is a matter of Scott Prather, case number RC 2025-0002. The matter is before the commission today for review of the initial decision and issuance of a final agency order. Present to assist the commission in reaching a final agency order are Melissa Phipps, Senior Advisor, and Marcia Waters, Division Director. An initial decision upon default was issued in this matter on April 2nd, 2025. Neither party has filed exceptions to the initial decision, and the matter is now before you on the commission's own motive to review the initial decision. The commission needs to deliberate on whether to adopt, modify, or otherwise act on the initial decision and proceed to a final agency order and final discipline, if any. Ms. Phipps, can you please provide a brief overview of the issues to be considered by the commission?
Yes, thank you, Commissioner Lind. Before I get started going into the issues, I just wanted to take a second to make sure that everyone is clear on the parameters of our discussion today. Director Waters and myself were both available to answer any general questions that you may have regarding this matter, but I just want to clarify that we cannot offer any legal advice. Your general counsel and other attorneys from the AG's office are not able to participate in any discussion or answer any questions, because in this case, they're walled off from this portion of the process since they participated in prosecuting the case. In some cases where there's complex legal issues or questions, we will have conflicts counsel appointed in order to help you work through the legal issues like we did in the previous case. But in our opinion, that didn't seem necessary in this case. So hopefully Director Waters and or I can guide you through any questions generally about how to proceed in this case without needing legal advice. If it comes to you guys thinking that you do need legal advice, then we can kind of shift gears and plan to take care of that in the future. But for today, just to give you a real quick overview of what's going on. I know Commissioner Lind touched on it a little bit, but just to go over it again, the matters before you today after the ALJ's issuance of an initial decision. Neither party filed exceptions. And normally what happens in such a situation is that division staff, now myself, through a standing delegation of authority that we have from the commission, we just review the initial decision, and if the outcome is consistent with what the division was seeking, we just go ahead and draft and issue the final agency order. And in this particular case, although the outcome was generally consistent with what the commission was seeking, there were two issues that staff felt required consideration by the commission before a final agency order was issued. And both those issues were addressed in the memo that you received as part of your meeting materials prior to the meeting, but I'll just take a minute to quickly highlight them. The first issue is incorporating the notice of charges into the final agency order. And as you can see from your review of the initial decision, it's pretty basic and scant on information regarding the case. Normally the initial decisions have just more information, more of a review of the facts than what we've seen here in this particular one. The ALJ didn't make any specific findings of fact or conclusions of law in the initial decision. Instead, the ALJ just stated that she finds and concludes that the allegations and the commission's notice of duty to answer, notice to set, notice of hearing, and notice of charges are established. So as that initial decision is written, it doesn't provide any factual background or support for that conclusion that she made. And then additionally, I think it's also kind of important to point out that there's no information in that initial decision that we would be basing the final agency order off of that would provide any factual background or information to any future reader of the initial decision or the final agency order, and that could include members of the public. So there's really no mechanism in those documents for anybody to actually understand the facts of what occurred in the case, and that may be relevant in the future, just for people to know what actually happened. So it's staff's recommendation that we strengthen the FAO a little bit by incorporating the notice of charges into the FAO. And that's really a pretty simple process. We just have to include language in the FAO stating that the notice of charges is incorporated by reference. And then by doing that, all of the facts and the allegations contained in the notice of charges become part of the FAO. And then that will actually attach that notice of charges document as an attachment to the FAO. So all of that information will be there, readily available to anyone who views the final agency order. The second issue is the ALJ's refusal to impose the statutory surcharge on the fine. So the initial decision did order the respondent to pay the fine that was requested by the commission, but the ALJ declined to impose the statutory surcharge as was requested. And the ALJ's reasoning was that the relevant statute grants authority to the executive director of DORA to collect that surcharge and not the division. But however, the commission and all of the division programs regularly collect that surcharge through a delegation of authority that the executive director of DORA has given to all of the division heads to collect that surcharge on her behalf. So essentially, we as division staff respectfully disagree with the ALJ's determination that the division lacks the authority to impose that surcharge. So we would recommend that you go ahead and impose that surcharge on the fine that has been imposed. So that's the background. Commissioner Line, I guess I'll turn it back over to you so that you can open it up if the commissioners have any questions or for the commissioners to discuss the issues before us today.
Okay, thank you, Ms. Phipps. Commissioners, do you have any questions or any discussion?
I do have a question. So in our package of information on this case, there was it's noted as a final agency order. And then on the last page of that, which is, or no, sorry, on page 3 of that, there was a list of charges. But then you mentioned that there would be an attachment list of charges?
It's the notice of charges was not attached. The ALJ it was not attached to it. So it would be the notice of charges would be attached.
Oh, okay, gotcha. And just and so the charges that we're looking at was censure, the civil penalty of the 2875, and then that's pretty much it, right? Okay.
Yeah.
And then what do we do if we are in agreement with this?
We're gonna need to make a motion to modify the initial decision
Okay.
with these changes, incorporating the notice of charges and also imposing the 15% statutory surcharge.
Okay.
So I would be pretty comfortable with that. It does look like we just need to incorporate the notice of charges as part of the FAO. And notice that it looks like the ALJ erred in finding that there was a lack of authority to impose that statutory surcharge. I don't have any other questions, but I can go ahead and make a motion unless there are other questions by the other commissioners.
I don't have any questions either.
Okay, go ahead, Erica.
So I would motion to adopt the proposed FAO with any revisions that were discussed and decided upon during the meeting, and delegate authority to the division to make any necessary non-substantive revisions, execute and serve the FAO.
Okay, can we clarify the motion just a little bit that we're going to
To incorporate the notice of charges as part of the FAO, and to impose the statutory surcharge that is within the commission's authority as a function under the direction and supervision of the executive director.
Okay, thank you. Second, anyone?
Second.
Okay. All right. And okay, we have a motion, so let's take a vote. All those in favor?
Aye.
Okay, Erica's the only one who said anything.
Aye.
Aye. Okay, all right. Motion passes. So, okay, so the final agency order reflecting the commission's decision will be issued in due course, and a copy will be mailed to the parties by the commission staff. That concludes today's hearing matters, and we can now move on to policy matters. And I'll turn it over to Director Waters.
Commissioners, we just need to circle back really quick to public comment. I don't think that we allowed the public a chance to actually address any issues with the commission that aren't on today's agenda. So David, can you see if there's anybody from the public that wishes to address the commission?
Thank you, Director Waters. If anyone would like to address the commissioners today, please select the raise hand icon from the Zoom utilities menu. And while any other individuals may do that, Roseanne Perez, I have unmuted you or allowed you to unmute yourself, excuse me. You have 3 minutes to address the commissioners. Thank you. Once you unmute, that is. There you go.
Thank you. I'm just actually wondering if my initial license was going to be heard today. I was told by the Tabitha that it was going to be heard today for Roseanne Perez.
It's on the agenda.
Okay, thank you. That's all I need. I'll stay on. Sorry, guys. Thank you.
Okay.
Commissioners, not seeing any other hands raised at this time. I think we can proceed on to policy matters. Thank you very much.
So commissioners, you have a new real estate commissioner, Bernadette Bougeron. Bernadette, would you like to do an introduction? And we'll also go through and do an introduction so that you know who all of us are as well. But we'll let you go first.
Thank you. Well, good morning, everybody. My name is Bernadette Bougeron. I'm happy to be here and happy to serve. So I work for a local credit union. on our business development team and just here on the public seat. And so thanks for having me.
Thank you for joining.
Welcome.
Welcome.
Commissioners, would you like to do an introduction for her as well? Renee, do you want to go first?
Sure. I'm Renee Lind. I am the property manager representative, and I am in Colorado Springs.
And
Erica?
my name's Erica Sanders. I am one of the real estate agents representatives out of Denver area. And welcome.
I am Erica Doyle. I am one of the real estate representatives as well. I am out of Grand Junction, Colorado, so West Slope.
Hi, Bernadette. Welcome. I'm Autumn Rubal, and I'm also a public member, so welcome. I am based in Denver, and welcome to the team. We're excited to have you.
Great.
Bernadette,
Thank you,
we've met,
everybody.
so you know who I am. Melissa, do you want to give an introduction?
Hi, I'm Melissa Phipps. I am the senior advisor here at the division, and I assist in a variety of different things like rulemaking, the exceptions process, and just different other projects. So you'll probably get emails from me before every meeting, and I apologize. It's usually a lot of material, but that's my job.
Jared, you're next.
Hi, Garrett Lyle, and I'm the Deputy Director with the division, and I oversee the investigation and enforcement section.
David?
Good morning, Bernadette and other commissioners. David Donnelly, I'm the manager of the Education, Communications, and Policy program for the division, and do some of the tech behind the scenes stuff here with these meetings. So thank you, and for joining us, and look forward to working with you all.
Penny.
Good morning. I'm your expedited settlement program manager, so I will work to resolve your cases, and then I work with your attorney general as your representative as we litigate cases.
And I think you've met Irina. You will meet more division staff as we move through the agenda. But commissioners, the first item up on your agenda today is selection of leadership. It is that time of year. You don't have a chair anymore with Michelle Espinoza rotating off. So you will be selecting a chair and also a vice chair at this point.
Okay. So do we just start the conversation?
Sure.
Okay. Well, I know Renee has been here a while, so it seems appropriate that you take that chair role. And I guess a quick question, was there a vice chair already?
I'm vice chair currently.
Okay, so yeah. Okay.
I would agree with that, absolutely. And I think, Erica, you would make an amazing vice chair.
Oh, that's so sweet. Thank you.
The words out of my mouth.
Okay. Well, thank you.
Okay, do we need to make a motion?
We need a motion and a vote.
Great. Well, I will motion that Renee Lind would be the chair and that Erica Sanders would be the vice chair.
I'll second.
Okay, Autumn second. All right, and all those in favor?
Aye.
Any opposed? Okay, motion passes.
The next item on your agenda is an update on the 2026 forms. I will turn this over to Melissa.
Hello again. As you guys are aware, we've made some changes to our forms committee process this year. And basically what we've done is take the administration of the process more in-house. So instead of having all of the changes made by the forms committee as we go along, where they're constantly revising, we've brought that in-house so that It's just kind of easier to have all of the editing and everything done in one place. And it takes a little bit of the burden off of the forms committee, where they just get to like focus on the substantive issues and not have to worry about the editing and everything. So where we're at so far is that all of the proposed revisions, well, I started out making some proposed revisions to all of the forms that are up for review this year. And all of those changes have been presented to the forms committee for their review and their feedback. We had a meeting during which the forms committee provided us with direction on which changes they supported, which ones they rejected, and which ones they thought needed to be tweaked or further refined a bit. So then I began working through the drafts and making the corrections that were discussed during that forms committee meeting. And the versions that were provided to you guys in your meeting materials are the red line accepted current draft versions. So I really kind of want to emphasize the words current and draft, because these versions reflect the state of the forms at this point in time. I still have to go back through and verify that all of the changes discussed during the forms committee meeting, that I've made all of those decisions, and I'm continually proofreading for just non-substantive errors like correct paragraph reference numbers and things like that as I'm going through and working on the drafts. And also I have kind of a running list of issues that I need further clarification or feedback from the forms committee members on. So hopefully it's my intention to set up a meeting here coming up soon with some members of the forms committee to just give me further direction and clarification on those changes that I still have questions about. So again, it's just the forms that you've got today are just a snapshot in time, what they look like right now. And all of the versions do have the red lines accepted. So if the forms were to be presented to you today, this is what they would look like. But really, I guess the take home point for this whole long explanation is that the versions that you've got, they're not the final versions. They're just provided for you for informational purposes only, just to give you a preview of what the new versions of the forms might look like. You don't have to take any action regarding the forms at today's meeting. We will be scheduling a non-rulemaking hearing for August. And prior to that meeting, you will be provided a final draft of the proposed revisions. So you'll have adequate time to review that finalized proposed version prior to that meeting. Some of those drafts probably will contain some additional changes from the versions you have today, but I don't anticipate they're going to be anything substantive. It'll just be kind of me going back in and fixing up the wording after I have that follow-up meeting with the forms committee members, and just continuing to make little non-substantive changes that I find. So it's during that August meeting that that you guys will have to formally consider finalize the versions of the drafts and adopt final versions of the form. And those final versions of the forms would go into effect on January 1st of 2026. So if you guys did have the chance to look over any of the forms and I know it's a little bit difficult with the red line accepted versions, but if you've noticed anything about the forms and you have any feedback, feel free to shoot me an email or give me a call and let me know if you guys have any further feedback and things that you want to be taken into consideration. But again, you'll also have the opportunity to have a full discussion between and amongst all of you at the August hearing about the proposed changes.
Could I throw out one thing? I can
Sure.
email you too, but there is an advisory to seller on the seller's property disclosure for land. And my question or recommendation would be, why isn't that same disclosure on the residential SPD? If that's something you guys could look at, or discuss. I know they're not finalized yet, but I'm not sure why it's on the land and not the residential as well.
Okay. I know I did some moving around of the advisories and kind of combining them. So I may have just not made that conformatory change to the land that I made to the residential, but I will definitely go back and look at it and verify.
That'd
And
be great.
thanks
Okay.
for bringing that up.
Yep.
And Melissa, will we get the actual red line version so we can see the changes with the amount of material that we get? It's just very difficult to see all of that without knowing what specifically we're looking for, particularly if they're very minor changes that they're making. So at that point, will we get the red line version as well?
Yep. Prior to the August meeting, you'll get the red line versions as well.
Okay. Great. Thank you.
You're welcome.
And then I'll just say, I will reach out to you just through email. I know on the list, the exclusive right to sell listing contract, that section, which it looks like it's still pending revision, based on the notes here. There's been a lot of conversation about that in the industry, and so I'll just shoot you an email just about my thoughts on that and kind of what conversations have been surrounding that, like compensation, how that's dealt with this particular form.
Okay, that'd be great. And if you can CC Marcia on that
Yes,
too. that'd be appreciated.
absolutely. Yes.
Thanks.
You're going to be getting some additional AG advice about listing contract modification. And the plan is that will happen in August as well, because you're likely going to have to engage in rulemaking before the end of the year too. But there's more to come on. It's germane to the whole supervision issue and waiving confidentiality. So that there is more to come on that one from the Attorney General.
Okay, thank you.
So commissioners, if that's it for the forums, we can move to your next item, which is legislative update. Fortunately, you went through 2025 legislative session without any bills that directly impact the Real Estate Commission itself. There were two bills that affect the division. The HOA sunset was passed, so that program, I think we're still just waiting for the governor's signature on it. But the bill passed to continue the HOA Information and Resource Center. There was also House Bill, I think it's 1043, that will require us to gather some additional information from HOAs during their registration and also provide some information to consumers about credit counseling and foreclosure resources. We were tracking over 40 bills that affected the real estate industry in general. And so right now, some of them are just kind of in this pending state where they haven't been signed or there hasn't been enough time that has passed that would then, segue into them becoming law. So we are waiting to see what the outcome is. And then once that happens, we'll go through to see if any of them impact your forms, because there were a couple that we were watching. And then, as usual, what we've done the past several years is we will issue an email blast to all of our licensees that will give just a legislative update of the different bills that impact the real estate industry that were passed. So unfortunately, nothing this year for you guys, but I would expect that you will see something next year since you are under sunset review currently. And then your next agenda item is just whether you have anything that you would like to have placed on the August agenda.
Nothing for me.
Nope.
Nope.
Okay. Well, that takes you into complaint investigations and audits, and I get to lead that off as well. Complaint matter A is case
A quick
number.
question. Would it be possible to take just a 3-minute break? Just for coffee?
I don't have any issue with that.
Okay, thank you so much. I just have to use the ladies' room.
Okay, let's say we'll be back at it's 9:47 now. We'll be back at 9. Let's do 9:55.
Thank you.
Okay. Okay, it looks like is everybody back? Bernadette, are you here? I see Autumn, Erica, the other Erica. Bernadette, are you there?
She's not back yet, but
Not yet. Okay.
while we wait for her to rejoin, that will give me an opportunity to give a plug for the Office of Policy Research and Regulatory Reform, just to remind everybody that the sunset review of the Real Estate Commission and the Division of Real Estate is ongoing. And if anybody has any comments and would like to provide those to Copper about the sunset review, Sahib Singh is on the call today as well. You can email him, and his email address is sahib.singh@state.co.us. He is the one performing the sunset review. And you have all of your commissioners back now.
Okay, so next we're going to move on to complaint matters, and I'm going to read a little bit more of this, especially for Bernadette, who's new. So the lead investigators will identify the complaint matter on the agenda, the case number, they'll read a summary of the case, they'll identify potential violations and recommend a possible case resolution. They'll also notify the board regarding who from the investigations is there to answer any questions. And okay, and so we'll start with complaint matter A.
And I will be the lead for these. Complaint A is audit number X 2025-29. This was an audit completed by Betsy Meredith. She is not here today. So matters A through F, you don't have the benefit of having the auditor here to answer questions, but I can phone a friend with one of the other auditors if you have questions. So with this one, during the routine audit, it was discovered that tenant funds were transferred to the rent account to disperse the security deposit to the tenant rather than issuing a check from the security deposit account. Additionally, both vendors and the brokerage were paid when funds were not available for the respective owner, causing the rent account to run a deficiency for months at a time. At the conclusion of the audit, the respondent was able to show that his accounts are fully compliant without negative ledger balances. The division is currently working with the bank to ensure the language for their trust accounts will ensure the safety of the funds. The respondent has already found another bank who will immediately open new accounts should that be necessary. Possible violations are 12-10-217-1H, failure to account for funds received, 12-10-217-1I, converting, diverting, commingling funds, 12-10-217-1M, violation of any commission rule or part 4, 12-10-217-1Q, unworthy and incompetent practice, commission rule 5.9, diversion conversion prohibited, 5.14, rule keeping requirements. And the recommended discipline is a stipulation for diversion, $1,000 fine, and follow-up audits consisting of 2 audits within 1 year. The first one not set to begin until 90 days have passed after the STIP is signed.
Okay, before we get in, well, this is part of discussion. As your property management expert, and we have a ton of property management cases today, I wanted to address a couple things. First of all, there's nowhere that I know of that's written that says you cannot transfer money from a security deposit to your rental account to disperse it. And I'm not sure why the investigators are saying you can't do that. It is commonplace with the accounting software. You do it at the time you are doing the security deposit disposition. You do all the work and then you transfer it. Check gets sent to the tenant and the rest of it goes to the owner to reimburse things. So I'm not sure why that is coming up. It is not normal for checks to be written out of a security deposit account. So, and there's nowhere that I know of that says you cannot do this. So I think the investigators should not be calling people out on this, because this is normal practice, and I don't see that it's against any rule or statute. If I'm wrong, you can correct me, but not that I know of. The other issue we are having has to do with bank accounts. And we do have a form on the division website that is a notice of escrow or trust account. And this was done in 2023 and was put up there. And this is standard that you get. You sign it, the bank signs it, it's telling them you need a fiduciary account. This has been accepted in the past. I am not sure why all of a sudden we are asking for the banks to provide account agreements showing that. Normally we get the signature card, and the signature card will say it's fiduciary, or it'll say it's a business checking. If it says business checking, it's not fiduciary. So I don't know why we are going down this rabbit hole of asking banks to provide all this background information. If we have a form that's developed by the division, we should be using that form, and it should be accepted by the investigators, as well as the signature cards that say fiduciary or not. The other thing I wanted to bring up about rentals has to do with the radon disclosure. And investigators are also hitting people saying that the radon disclosure does not have commission verbiage. It is not required to have commission verbiage. It is the disclosure. So we need to get away from that as well. People are being dinged for that as well. And it's not it doesn't have to have commission verbiage. And then we also have in multiple, especially on these first several, there is the investigator saying that unclaimed checks over 6 months have to be distributed to the Great Colorado Payback. And as far as I know, the statute is instructing that to be 3 years, not 6 months. So I am not sure where we're getting the 6 months from. And so we've got several things going on with these property management investigations that I think need to be corrected or addressed with these investigators, because I think they're not handling everything correctly, and they're not accepting things that they should be accepting.
So, commissioners, the division is working on a project right now regarding trust accounts, just because we have a lot of financial institutions that will say something is a trust account when it actually isn't. The big goal here is to make sure that they are actually trust accounts, so that, God forbid, if something happens with the broker, those funds are not swept. And we've seen that happen where a broker will declare bankruptcy and client funds get swept because those were not actually fiduciary accounts. So that is part of the reason that the investigators and the auditors are checking to make sure that they are actually fiduciary accounts, because we've had several banking institutions that have said that they have been fiduciary accounts and they're not. With the radon disclosure, they have to have, on a disclosure form that is not a commission-approved form, it has to say that this is not a commission-approved form. That's it. That's all they're looking for. And that's a requirement under the standard form statute and also the rules. I will ask for one of the auditors to speak to the whole rental income account versus security deposit account, but there is a reason that those two are kept separately. So at this point, Jay or Eddie, would you like to speak up on that one?
Sure. Hello. So I don't know the exact specific details of the case that was just presented and the issues that you're raising, but I can say that when we are conducting an audit, I would agree with you. I have seen it where a security deposit might be deposited into the rental account first and then transferred into the security deposit account. We have seen where the security deposits transferred into the rental account, and that's where kind of the expenses are made from the rental account. So I don't think myself or my team are being directed to cite violations of the license law when we see that specifically happening. So I can't speak to what happened in this particular case. I'm not familiar with that. But I don't believe that's something that our staff is citing as license law violations. There is a rule that requires property managers to have at least one trust account for rental proceeds and one trust account for security deposits. And we definitely are reviewing that. But we are aware of the kind of the general process of how security deposits are handled, you know, when initially being deposited into the security deposit account and when the disposition is taking place afterwards. And I don't believe that we are citing license law violations for kind of the example that you just gave and I gave just now.
Well, it is. It's right there on, it's the first line that it was discovered tenant funds are transferred to the rent account to disperse security deposit rather than issuing the check from the security deposit account. That's the very first thing, first line on this, and it was in the investigation. And that's what I'm referring to, is that when you're doing a security deposit disposition, that it is very normal that you transfer the funds from the security deposit account to the rental account, and then you write the check. It is not normal for checks to be written out of a security deposit escrow account for the security deposit disposition. And people are getting cited for it, and this case was one of them. So that's what I'm saying.
Okay, I understand that. And again, I wasn't familiar with these specific details of this case,
Yeah.
and I thought there was an element. I thought I heard something about the timeliness of that taking place as well. So maybe that's an element of why it was cited as a license law violation in this particular situation.
If I may interrupt, this is Jay McLean. I reviewed some of Miss Meredith's case that's being presented, and I completely agree with Eddie Rose in that we as auditors are not citing any issues if they are transferring security deposits to the rental to pay out. It is my understanding, although I cannot speak for Betsy Meredith, it is my understanding, reviewing all the documents and this case, that the money was not in the security deposit, and that the security deposit, the rental money was used to reimburse the security deposit, if that makes sense. That the money was never taken out of security deposit. It was simply just paid from the rental proceeds. That was my understanding on this specific case.
I think the person was transferring it. That's a normal process, that it's transferred from security deposit escrow to the rental escrow. And
I agree with that. I agree with that it's a normal process.
yeah. So, but that was one of the first things that this was on this one. And we just need to make sure that it sounds like, Jay, you know exactly what's going on, and Eddie too. So that's great that you guys know, but it seems like we're having some issues with people getting hit for things that shouldn't be. So I just wanted to bring those up so that we could address them and maybe make sure everybody's on the same page.
Absolutely.
Okay, so does anyone have any questions about this case or any discussion about it?
So I looked at the signature cards just while the conversation was happening, and on the signature cards, it did not have the fiduciary box checked on the two that were provided in the information that we received. So that's, but there's mention that you know, they're working with the banks on that particular issue. So I think part of the violation quote that we're looking at is that. Is that accurate? Is that an accurate assessment? Okay.
Yes.
And I guess the concern with that is exactly what Director Waters said, which is if you're requesting fiduciary accounts and then the banks aren't doing that, which we don't know in this case if that's what happened or not, but I think in the information that we received, I want to say that it did insinuate that that's what was going on. But it's like, what do we do in those situations when it's like the individual had every intention on having that fiduciary account, and as long as they're doing it properly, right, keeping those funds separate, I mean, how do we address that as a commission, I guess would be my question.
Listen. So the goal is to get them to either there hasn't been an update. I haven't gotten an update on whether the corporate branch of this lending institution has verified whether those are actually fiduciary accounts or not. So that's still an outstanding question. But if they don't have fiduciary accounts, then the broker needs to move them to a financial institution that does offer those. The goal is to gain compliance here. And so that's part of the whole follow-up audit, is to make sure that the accounts are fiduciary. There's no negative balances. One person's funds aren't being used to cover somebody else's deficiencies.
So the other item that was an issue in here that I saw had to do, as you're talking about the negative balances, there are owners that have several different LLCs. And the comment was, well, it's okay because I have money in one of the other ones. If you're doing an LLC, that is a separate thing and they're not together, and you should not be able to put a negative balance on one and say, oh, it's because the other one is positive. An LLC is different. It's not like it's just under one owner and you can move things. If it's under just one owner name, that's fine. But if it's under an LLC name, you should not be using different LLCs to fund other properties that are negative, because it's a different, in essence, it's a different property, different owner, because it's a different LLC. So that was, I don't think property managers should be doing that. In this case, this one was.
Yeah, it seems to me like with what you just taking in consideration what you said earlier, I'm gonna tell you, I do not know a lot about property management. That is not my area of expertise, so I am relying on your expertise there. It seems like in the referral, it says, additionally, both vendors and the brokerage were paid when funds were not available for the respective owner, causing the rent account to run at a deficiency for months at a time. So that to me definitely seems like a violation.
Absolutely.
I'm on the fence with that fiduciary account because it does say that everything is in compliance, and I get that they didn't have that set up, but I guess I'm still struggling with maybe because of the information they were receiving, they thought it was, but it does say that they're working with the bank to ensure the language for their trust accounts will ensure the safety of the funds, and that they've already found another bank who will immediately open new accounts should that be necessary. So I guess all the statutes still apply based on that section with that mentioned the deficiency. So it seems like the statutes and the rules still apply, right? And so I guess really the only question I would have is $1,000 fine fair or no? Based on the information that you provided, Renee, about that first.
Yeah, I don't know.
Not being,
Anyone else want to weigh in on that? Erica, Autumn, Bernadette, anyone else have any questions, comments?
Well, I think if we're going to do the 2 audits, that's going to be able to catch the trust account deficiency. So I think they definitely need some coursework So I think that we need to make that happen as well. I thought you brought up a good point on the transfer, but I don't know that that necessarily applies for the security deposit. On this particular one, it seemed to me that the fine was low for running so in the red. But I think more on this one, we definitely need the education and the audits to make sure that they're compliant and those funds are there moving forward.
What would you like to see the fine? What would you like to, instead of 1,000, did you want to suggest something else?
Do you have a suggestion on that? I mean, again, this is your expertise.
Well, I think it's reasonable to increase it some. I mean, I would say at least 2,500, and the boxes on the referral for the coursework aren't checked. I think that's probably just an oversight, but I think we definitely need to check the boxes for the coursework and trust accounts and property management. And this is
I would agree with both of those.
Yeah, this is another one of those cases that is a great support for having a property management license and training everybody how to do these things, because it seems like people really are getting into trouble with all these trust accounts. So do you want to make a motion, Erica, one of them? So
I'll make a motion in complaint. Let's see here.
in matter A.
In matter A, I would move to accept staff recommendations, changing the fine to 2,000, having diversion, audits, 2 audits within 1 year. First one not to begin until 90 days after stipulation, adding coursework and property management and trust accounts.
Okay, is there a second?
I'll second.
That Autumn, okay. All right, any further discussion? Okay, all those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion carries.
So Commissioners, complaint matter B is audit number X 2024-114. This is another audit performed by Betsy Meredith. This is a routine audit open on the respondent, though many smaller items were corrected during the audit in a timely manner. Trust accounts remain a concern. The broker was provided numerous extensions and was issued a final notice to comply. Negative ledger balances and the broker's funds being used to offset accounting errors is of ongoing concern. Additionally, the respondent appears to be delegating her trust accounting and relying on an out-of-state software company who may not be aware of Colorado license law. Potential violations are 12-10-217-1H, failure to account for funds received, 12-10-217-1M, violation of a commission rule or part 4, and commission rule 5.14, record keeping requirements. The recommendation for this case is a stipulation for diversion, $1,000 fine, coursework and trust accounts, and a follow-up audit no earlier than 90 days. And again, Betsy is not here to answer any questions that you may have.
Okay, any discussion on matter B?
My initial notes were that I was in agreement with the proposed discipline. But if anyone else has any comments on it? Yeah.
I would agree.
I agreed.
Can I have a motion?
Yeah, I agree with that. I thought the fine could have been a little bit higher. I think she's out of state. There's not enough oversight on that. And so I did think that it could have been a little bit higher of a fine.
What did you think the fine should be?
You know, I'm not familiar with what all the fines are that we usually hand out. I know when I looked at that compared to the other cases that I've read over, I just thought it was a little bit low.
There's a maximum fine right now of $2,500 per violation.
Okay. I would probably do the 2,500. I feel like, you know, she's not in state. There's a lot of stuff that goes on that she oversees and is not really mixed in it. And maybe it would encourage a little bit more, participation in what's going on.
Well, maybe we match it to the last one, which was a $2,000 fine. What do you guys
That would be
feel
fair.
about- What do you guys feel about that?
I mean, it's consistent.
Yep. Do you want to make a motion for that?
Okay.
What is it? Oh, do you want to go ahead? Go ahead.
Oh, no. Yeah, go ahead. Because, you know, I have to
It's
get
always the
myself together
lingo
for
that's
the motion.
intimidating. I move to accept staff recommendation with the exception of increasing the fine from 1,000 to 2,000.
Okay, is there a second?
Second.
All right, all those in favor?
Aye.
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 Any opposed? Okay, motion passes. Yeah.
Commissioners, complaint matter C is audit number X 2024-121. This is a audit completed by Betsy Meredith. Upon reviewing a website for a third-party property management company, it appeared that the company was not licensed with the division and that the respondent, an associate broker with a different brokerage firm, was running the company. After speaking to the respondent, it appeared that he did not have trust accounts, compliant property management documents, and was not obtaining a brokerage disclosure addendum, BDT or radon disclosure and brochure. It also appeared that negative balances appeared on the tenant ledgers. At the time of the interview and in reviewing the submitted files, it appeared that the respondent had sold his company to a new broker and has inactivated his license in order to pursue a different career path. Possible violations include 12-10-217-1M, violation of any commission rule or part 4, 12-10-217-1Q, unworthy and incompetent practice, 12-10-217-1H, failure to account for funds received, Commission Rule 5.14, record keeping requirements, 7.1, standard forms, 6.5, brokerage relationship disclosures in writing. Recommended discipline is a stipulation for diversion and coursework and trust accounts to complete when he reactivates his license.
It seems considerably low in comparison to the other discussions we've had.
Yeah, I was kind of curious why I felt the same way. I felt like it was a little light considering he was operating this company without a license. And I understand he was a newer agent from what I recall and may not have been completely aware, but there was no communication with his broker. They had no idea what was going on. And so, yeah, I thought it was a little light. The other thing is he's no longer licensed. Therefore, what are the chances of ever him really feeling this discipline, right? So, I think the fine was low.
Could we put a discipline on it? Should he reapply for license?
He has he's inactive, so he still has a license.
Oh, he's
Okay,
inactive.
thank you.
Okay.
Inactive.
And if you want to issue a fine, that's fine. I think the mentality was the fact that he was a brand new broker. And you will hear the case here in about, I think, the next one of his first employing broker. It's a he said as far as what he was told he could do and what he couldn't do. And then it would appear, at least from my perspective, that once he became aware of it, he did what he needed to and got rid of the book of business. He actually, not knowing what he was doing, probably did a better job than some of the other licensees that you see that actually do practice in this arena regularly.
Yeah. And that's a great point. My notes initially said like $2,500 fine, but I think that that's a really good perspective to be considered.
I don't
Can
know how
we-
big of a deal this is, but on the form itself, the fine box is not checked, nor is the coursework requirement.
I
do
will
see-
say that I don't know what is going on with Adobe and Google with these.
I do see a note that he can stay coursework until he returns to an active license, but
Okay, when we
Yes.
make the motion, we'll just make the motion and say, make sure that those items are included.
okay, so I move to accept staff recommendation with an added note to ensure that the fine box of $1,000 is checked, along with the coursework in trust accounts is checked.
Is there a second?
Second.
Okay, all right, all those in favor?
Aye.
Aye, all right, motion passes.
Okay, complaint matter D is audit number X 2024-120. This is the first employing broker for the last one that you just heard. This audit was open when the auditor realized the respondent's associate broker was running a full service unregistered property management company. It appears this respondent, who was not aware of the activity of his associate. Additionally, this respondent was not disclosing conflict of interest and license status on his own broker-owned properties, nor despite numerous requests that has he established a fiduciary trust account to hold money belonging to his tenants. The respondent himself and his associates appear to be mixing documents and email address with an affiliate, but separately licensed entity and websites appear to remain out of compliance. Exclusive right to lease agreements have not been obtained on any of the sampled leases. Sampled sales files indicated that only partially executed documents were retained, and the errors and omissions insurance coverage was corrected only after a correction request, a final notice, and then after they received notice that the brokerage would be deactivated. Possible violations include 12-10-217-1M, violation of any commission rule or part 4, 12-10-217-1Q, unworthy and incompetent practice, 12-10-217-1R, failure to supervise associates per Rule E31, Commission Rule 5.21, production of documents and records, 6.5, brokerage relationship disclosures in writing, 6.10, advertising, 5.11, earnest money on new construction placed in a trust or escrow account, 7.1, standard forms, 6.2, competency, 6.3, supervision, and 3.9, errors and omissions. Recommended discipline is a final agency order with public censure, a $4,000 fine, coursework in brokerage administration, record keeping and trust accounts, and legal issues, and then 4 audits over 2 years. And that is the end of the recommendation. Betsy Meredith isn't here to answer any questions. But I know that Jay reviewed this, should you have questions.
I did have one question. I just, it was 511, the earnest money on new construction placed in trust or escrow. I didn't see anything in the report about that, so I was just kind of confused on why that was there. And maybe I missed something.
Well, I reviewed the report yesterday and I don't recall seeing that either. So if you want to have that removed, that is totally fine.
Okay. Otherwise, I mean, I felt that there were a lot of violations, quite a few violations, but it seemed to me that the discipline was appropriate.
I agree. I thought there was a lot of confusion as to what brokerage was involved with what. You know, I know he adamantly denied that he was given permission to operate the property management position, business, but there was just a lot going on with his own business right there. So just focusing in on that alone, I think that this was appropriate. And I agree, I didn't see anything on the new construction piece, so I would remove that.
Any other discussion, or someone want to make a motion?
I can make a motion, bear with me here, but motion to accept the staff recommendation with the proposed change that 5.11 earnest money on new construction sorry, I can't see this. Earnest money on new construction placed in trust or escrow be removed. And also check the other box requiring 4 audits over 2 years.
Do I have a second?
Second. I do have one question on that, though. I'm noticing on some of these others that we're starting those audits 90 days after a stipulation is signed. Is that something that we want to add on to these?
How does that typically work if any of the investigators or even Director Waters, how does that typically work with the audits in this case where it just says 4 over 2 years? Is there like a system and when those audits happen?
Well, so it depends on whether you give us more kind of refined direction.
Okay.
4 audits over 2 years, hopefully they are kind of spanned out maybe every 6 months, although I don't necessarily know that that sometimes happens. When you specify not to start for 90 days, at least that gives them the opportunity to try to apply the direction that they have gotten through the audit process and also from the commission hearing to their practices. This one's a little different though, where these are issues that like you should have had resolved probably before this case came in front of you. From the reader's perspective, it seemed to be kind of a battle of the wills at some point on a few things. The fact that our licensing manager had to step in and say, like, if you don't get this corrected, we're going to inactivate the entire brokerage. That doesn't happen very often. So I can understand not wanting to wait 90 days before doing an audit, but they should be kind of spaced evenly amongst like every 6 months if it's going to be over 2 years.
Okay, and I agree with that on here. That was just the first time that I'd seen some of that come up, and so I wanted to know if that was more a scheduling thing on staff or what the reasoning was behind some of those. So I'm not making any changes here, but I did. I was curious about that. Thank you very much.
Okay, so we have a first and a second. All those in favor?
Aye.
Aye.
Aye. Okay, anyone opposed? All right, matter passes.
So the next one is complaint matter E. This is audit number X 2025-125. This was an audit completed by Betsy Meredith. This stems from a routine audit open on the respondent, ongoing concerns surround missing money in the security deposit trust account, standard forms not being updated, and disclosures not being made in a timely manner. Possible violations include 12-10-217-1H, failure to account for funds received, 12-10-217-1I, converting, diverting, commingling funds, 12-10-217-1Q, unworthy and incompetent practice, 12-10-217-1R, failure to supervise associates per Rule E31. Commission Rules 5.9, diversion, conversion prohibited, 5.10, commingling prohibited, 5.14, record-keeping requirements, 6.3, employing brokers, responsibilities and supervisions, 6.5, brokerage relationship disclosures in writing, and then Rule 7.1, standard forms. Recommended discipline is for a stipulation for diversion, a fine of $2,500, coursework and trust accounts and property management, and then 2 follow-up audits within 12 months. And as with the others, Betsy is not here to answer any questions.
Okay, so I have an issue with one of these with the follow-up audit that we need some clarification on the security deposits. Security deposits remain in security deposit trust. That's not, they do until you do the security deposit disposition. So I think that needs to be removed because security deposits don't always remain in the trust and security deposit trust. They are moved to the other one when you write the checks out for it.
Can we
So
buy until dispersed? Because we
Um,
enter
or,
trust account.
yeah, or something, or until, I don't know, something with security deposit disposition. Yeah, I'm not sure how we word that, but obviously the security deposit should remain in security deposit trust. But when you're doing the disposition, when you're finalizing the security deposit, we could say that until security deposit disposition is finalized, maybe?
How about disposition or disbursement?
Okay, disposition or disbursement. Okay,
And if I may, commissioners, this is Jay McLean. In reviewing this audit case, there was a review of the disposition of the security deposits initially held by the property management company. So the auditors are reviewing the percentage of security deposits that are retained. And that is, there was one security deposit that this auditor had concern about, that the disposition of it was not properly dispersed in a timely manner. I don't know if that is the question you might have with this. We're not talking, Betsy Meredith was not necessarily saying that the money was moved from security deposit to the rent and then paid out. That was not the violation that I picked up on. The concern was there was one specific security deposit that was held on to for more than 60 days before a portion of it was returned back to the tenant.
well, I think with Director Waters' verbiage, that would cover it. If we're saying it's to remain in the security deposit escrow account until disposition or disbursement, I think that would cover that situation as well.
Okay.
Do you agree that
Yes,
it's not being dispersed, so it's staying until that happens?
I agree with that.
Okay. All right, any other discussion or questions?
No.
No.
Huh?
Okay, someone want to
Okay.
make a motion?
Motion to accept staff recommendation with the following adjustments. Under the audit, number 2, security deposits will remain in the security deposit trust until disposition or disbursement.
Okay. Second?
Second.
All right, any further discussion? All those in favor?
Aye.
Aye. Anyone opposed? All right, motion passes.
So Commissioners, complaint matter F is the respondent that purchased the company from the respondent in complaint matter C. This is audit number X 2025-4. It was an audit performed by Betsy Meredith. This audit was opened on the respondent after it was discovered that she had purchased an out-of-compliance property management company. During the course of the audit, the respondent made numerous corrections. However, there appears to be over $100,000 in negative ledger balances across her various accounts. Most of the final set of reconciliations are also missing documents required to determine the status of the account. The respondent will need to work with a software company or a forensic accountant to determine the root issues and make corrections as needed. Possible violations are 12-10-217-1H, failure to account for funds received, 12-10-217-1M, violation of any commission rule or part 4, 12-10-217-1Q, unworthy or incompetent practice, commission rule 5.14, record keeping requirements, 5.1, establishment of internal accounting controls, 6.2, competency, must possess experience, training, or knowledge. Your ESP referral shows failure to supervise. She doesn't supervise any licensees, so please ignore those. Those are an error. The recommended discipline is for a stipulation for diversion, a fine of $2,500, coursework and trust accounts and property management, and then 2 audits within a year, the first to start 90 days after the stip is signed. And as with the others, Betsy is not here to answer questions if you have any.
Okay, so you said we're removing 12-10-217R, and we're also removing 6.3. Was there, those were the only two being removed?
Yeah, the violations regarding supervision are being removed.
Okay. All right.
I have questions. And also just keep in mind, I don't think this has come across our desks in the time of my commission. The asset purchase agreement is dated 12/12 of 2024. So as I was kind of reading through this, I came to the conclusion that she inherited this by proxy through purchase, not that she had actually completed or did these violations herself.
That is correct. This is this audit was commenced as typical when a property management company buys a book of business. It is common that we will then audit the new company, the new broker who has purchased the book of business. The violations, the findings that were found in this particular broker's audit are not related to the book of business that she purchased. She was specifically asked if she found any deficiencies when she purchased, financial deficiencies when she purchased the book of business, and the broker indicated that she did not find any issues with that. And so the findings on this particular case have to do with the pre-existing book of business that this broker had prior to taking on the business.
Thank you for that clarification.
You're welcome.
I just have a quick question, if we could step back just a little bit. On the 1210-217R, excuse me, I don't know what's going on with my voice. Failure to supervise, but it says bookkeeper. So is that one remaining? I know no. Okay.
We are removing that one.
Okay.
Any violations regarding supervision are being removed.
Got it. I really didn't take any issue with the recommended discipline. Interested to know what my counterparts think, but I was in agreement with what was proposed.
There are a lot of concerning things on this audit. Did she say anything about the $100,000 that was missing? 100,000 plus that was missing?
Well, I think what was documented in the report was that she wasn't aware of any missing money because she and the bookkeeper haven't been stealing anything.
I remember that.
Does this need to get turned over to AG or to someone else?
I don't know that there is sufficient information at this point to be able to assess that there's a concern that there's criminal activity going on. That was the reason for the statement of she needs to hire a forensic accountant to sort this out.
Okay. I thought that possibly the fine should be higher. There are so many issues, and if the issues are with her prior business, not with the new one she took on, there are a lot of issues going on. I don't know.
If she doesn't fix this in these upcoming audits, I mean, that's going to come back to you for potential additional discipline.
Okay. And we didn't say, does it say when the audits? It just says 2 within a year. No.
Correct.
Okay.
Well, the first one to start no sooner than 90 days following the signature stipulation.
Okay.
Do we
does any-
do we set a timeline or anything to get that for her to hire a forensic auditor and then or a forensic accountant for this? Is there a certain amount of time other than, is it just before the first audit?
So you guys are not requiring her to hire one, and that's kind of a touchy recommendation because you're requiring a licensee to then go out and hire an expert to perform work, which is really not kind of within the parameters of the scope of what you can impose as discipline. And I know that has been an issue with some past disciplinary cases. We can encourage her to do that. And frankly, if I was in her shoes, that's what I would be looking to do, particularly if I have 2 follow-up audits coming from the Real Estate Commission.
But if she doesn't do it, she does not required to do it, but she will be having another audit. And if she can get everything worked out herself, good to go. So it'll show whatever she does or doesn't do will show up on the next audit, and then it'll be addressed again.
Okay.
Okay, so does anyone want to make a motion on this? The motion needs to remove those 2 items, 2 violations.
Move to accept staff recommendation with modification to remove section 12-10-217 1R CRS for the failure to supervise bookkeeper, as it's not I can't talk today, applicable. And I think that was the only modification.
And removing 6.3.
Oh, thank you. And removing 6.3.
Okay, we have a second.
Second.
All right. Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Good morning, Commissioners. The next is matter G, complaint number 2024-1696. The investigation noted potential license law violations with the respondent's property management agreements, lease agreements, disclosures, E&O insurance, office policy, employee acknowledgement, and trust accounts. Possible violations are 12-10-217-1K, failure to maintain files for 4 years, 12-10-217-1Q, unworthy incompetent practice, 12-10-217-1M, violation of any commission rule or part 4, rules 5.5, trust or escrow required for rental receipts and security deposits, rule 5.14, record keeping requirements, rules 5.21, production of documents and records, 6.2, competency, must possess experience, training, and knowledge, 6.3, employing brokers' responsibilities and supervision, and 7.1, standard forms. Disciplinary recommendations are a final agency order, public censure, a fine of $5,000, coursework in brokerage administration, coursework in trust accounts, coursework in property management, and a license downgrade to an associate broker with a high level of supervision for 2 years. And Investigator Geske can answer any questions that you may have.
We have an issue with what's showing on the screen. We lost our agenda on the screen and there are other things showing. Okay, great. Thank you. Okay. Does anyone have any questions or discussion on this matter?
I just was trying to pull up my notes because, to be honest, I don't recall what I wrote about this one. So 1 second. Oh, here it is. Okay, let's see. So, I mean, yeah, my notes are that there's a lot of violations. I didn't challenge any of the violations, and I just agreed with the recommendations.
I agree. Anyone else have any other discussion or questions?
No, I agreed.
Agreed.
All right, someone want to make a motion?
Motion to approve staff recommendations.
We have a second?
Second.
Okay, all those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes. Do we have anybody for matter H?
Hello, Commissioners. Your next item is investigative matter H. This is complaint number 2025-607. On October 14, 2024, the respondent entered a plea agreement with Denver City and County District Court for insurance fraud. 18-5-211-1A, Colorado Revised Statutes, Class 1 misdemeanor. The respondent was sentenced to an 18 months probation, was ordered to attend Discovering Better Choices program through the Institute for Specialized Alternative Education, which the respondent has completed. Probation is scheduled to end on October 14, 2026. Possible violations include 12-10-2171M, 12-10-2171N, and Rule 623. Recommended disciplinary action includes diversion and a $500 fine. Myself and Investigator Jay McLean are here to answer any questions you may have.
The comment that I kind of noted was typically in these cases when there's active probation, what we've done this far is we make the disciplinary recommendation that the probation be kind of concurrent with their probation. So that was really maybe a suggestion that I can present. Would love to know what my colleagues think.
I agree as well. I had that down too. Okay.
Sorry, I lost my screen for a second. I couldn't find you guys. I was looking at the documentation. I would agree.
Like a motion?
No one want to make one? Make a motion?
Yeah, motion to accept staff recommendation with the proposed addition that probation would be concurrent with the respondent's scheduled probation. Hope I did that.
We have a second?
I'll second.
Okay. All those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes.
Okay. Your next item is investigative matter I. This is complaint number 2024-1036. On June 10, 2024, the division received a complaint against the respondent regarding a sales transaction in which the complainant represented the buyer and the respondent represented the seller. The complaint alleges that the respondent listed the property without first obtaining a signed listing contract, that the respondent's license was inactive during the transaction, and that the respondent failed to provide documentation pertaining to inspection resolution items. The investigation found that the respondent did not get an executed listing contract or provide brokerage relationship disclosures to the seller of the respective property, and the respondent's license was inactive during the transaction. Possible violations include 12-10-2171M, 12-10-2171Q, 12-10-4082B, and Rule 6.2, 6.5, 6.14C, and 6.26. Recommended disciplinary action includes a final agency order, a $2,500 fine, coursework and brokerage relationships, coursework and brokerage administration, and coursework and contracts. And myself and investigator Marcy Rivera are here to answer any questions you may have.
I have a question. Did you say final agency order on here? Because mine says diversion.
Yeah.
My apologies, diversion.
My question and comment kind of on this was, I just wanted to understand, I felt the fine was really low. There's several, to me, really important elements here. They didn't have a listing contract signed, their license was inactive. They didn't provide proper documentation pertaining to the resolution. They didn't get an executed listing contract to provide brokerage relationship disclosures. And to me, like the fact that their license was inactive, just, I don't know if they were aware or not aware, but that's a big deal. They probably were aware. So I just wanted to kind of understand the thought process of just the 2,500, because to me, it just seemed like a lot of major concerns.
Sure. After some discussion with other team leads and supervisors, I think we settled on 2,500 as kind of a starting place. The initial recommended disciplinary action regarding the fine was listed at 5,000, and we adjusted that. So if that is more in line with what y'all are looking for, I think is appropriate. That's certainly within your ability to vote on that, as well as thinking that this would maybe be a candidate for a final agency order versus diversion as well.
Well, I definitely think if diversion, that fine needs to go up. And my knee jerk was actually 5,000 as well, is what you said was the conversation. These are things we just have to set a standard on in the industry, that this is not acceptable, to have all these issues. So I'm of the opinion that 5,000 is more appropriate.
Erica, I agree with you. I also felt like it could have been 2,500 per occurrence.
Okay, I agree too that Eddie's first thought of 5,000 was correct. My next question would be, is this rising to public censure? Because there are so many items. Anybody?
I know he's a supervising broker, but was he supervising in that capacity as well at that time? Did he have anybody underneath him?
I don't believe he did, or he does currently, but I can look into that really quickly.
One more question, and I don't remember. Did he ever provide the resolution items? I remember, I read this entire package as everything else, but I just couldn't recall that part. If he ever actually handled the resolution items.
I'll let Marcy speak to that.
Morning. So these, what you're asking about is the furnace, correct, and the roof?
Yeah, I just can't remember what the report said in regard to the fact that he failed to provide documentation pertaining to the inspection resolution item. So I was just wondering, was that ever provided even after the fact, or was it just never provided?
So these were some items that the buyer's agent then reached out to, like the city, regarding getting the notification regarding that there was a permit pulled for the furnace, and then regarding the roof, there was a lot of back and forth. They were trying to get it covered through insurance, and of course it got denied. But this was all after the fact, and so it was the buyer's agent that really did what needed, I guess, to be done after. And that this was all, of course, items that were to be handled after closing.
Okay.
But these were items that were requested prior to closing, but unfortunately weren't done. And so the buyer and the seller agreed to allow these items to then be addressed completely after closing, which the buyer's agent did do.
Okay.
And this respondent doesn't currently supervise anybody. I need to do a little more research to tell you for certain whether some of the people that they supervised in the past would have been under this brokerage firm at the time of this investigation. I don't believe that was the case.
Yes, so to my knowledge, he was not, there was no one under him at the time that he was inactive and during this during this the transaction when he was inactive while the home was listed and closed.
Okay.
Marcy. Renee, we do have a couple people with their hands raised.
Commissioner Land, I think I may, I want to comment on your question to the commission about public censure. So I just want to highlight that because currently it is a diversion, which is lower type of discipline and it's not publicly visible. So pairing it up with public censure is a bit problematic. If you are moving away from diversion to final agency order, then public censure is back to the discussion. But if you stay in with the diversion, probably public censure is not a good option to pair up.
Thanks. Thanks.
We can move this to final agency order though, correct?
Yes. So Garrett has his hand up.
Thank you, Commissioners. Yes, I was just going to address the perceived light discipline. That's likely my influence. In general, the disciplinary recommendations are come from the division from a historical perspective of how we've handled similar cases with similar fact patterns. In this case, as I have more and more influence on the disciplinary recommendations, I'm taking more of a lower end of that disciplinary range, but I will use your discussions, your feedback, and your opinions to shape those recommendations in the future. So if you see additional complaints coming up that you think might be a little bit on the lighter side, I would just encourage you to discuss that, explain your reasoning, your opinion, and then we will use that to shape those disciplinary recommendations moving forward.
Okay,
Thank you. Yeah, in this case, I do think that really the fine was low. I'll kind of look to my colleagues in regard to diversion versus final agency order. My thought, as I mentioned earlier, if it's particularly if it's diversion, I think that fine needs to be increased because there were, to me, what are significant challenges in this case, But I would love to get feedback from the rest of the commissioners, whether your thoughts are diversion or final agency order. I think for me, I was, diversion seems okay, but I would love some commentary on that.
Eric, I agree with you. I think diversion is okay. I do think that $5,000 is appropriate on the fine, based on reading all the material.
Okay, anyone else have comment?
No.
Okay.
Autumn, and then Bernadette, because I know you brought up the
Final agency.
final agency. Yeah, I mean,
I feel because I'm fairly new to it and I'm kind of watching it, but I feel like protecting people, protecting the public, that's a big deal. Not saying anything and it going after closing and there being issues after closing, to me, that's a big deal. But I do like the higher fine on that. So I will stick with what you all are.
You don't have to lower the fine if you do the FAO. You don't have to do that. You can do both if you want.
No, I do like the higher fine on it for sure. I just didn't know if between the diversion and the final agency order was kind of my thought. Because I feel like protecting the public is a big deal. And if he didn't say anything ahead of time and it goes until after closing, that could be a problem for, future transactions if they continue to do something like that. So, but like I said, this, I'm looking at it and maybe the diversion will, help that in the future, that maybe they would be a little bit more cognizant of that.
Okay, does someone want to make a motion then?
I motion to accept staff recommendations with the change of fine to $5,000.
Is there a second?
Aye.
Okay. All right. All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Okay. Your next item is investigative matter J. This is complaint number 2024-285. You also have the same respondent on the following case for your information. On February 5th, 2024, the complainant submitted a complaint to the division stating that he hired the respondent to manage his property. The complainant alleges the respondent is performing activities that require a real estate license. The complainant alleges that the respondent has failed to remit rental proceeds totaling approximately $22,000, has also failed to return the tenant's $1,495 security deposit. The records provided by the complainant and his tenant appear to indicate that the respondent is performing activities that require a real estate license. The respondent did not provide documents requested during the investigation. Possible violations include 12-10-202, license required. Recommended disciplinary action includes an injunction and referral to criminal law enforcement. And myself and investigator Marcy Rivera can answer any questions you may have.
I didn't have any questions on this. I mean, he doesn't have a license, so I know our jurisdiction is limited. So I definitely agree with the recommendation that it be referred to law enforcement.
Agreed.
Agreed.
Okay, someone want to make a motion?
I move to accept staff recommendation.
Second.
All right, all those in favor?
Aye.
Aye.
Aye, motion passes. Oh, sorry, anyone opposed? Okay, motion passes.
Next matter is investigative matter K. On December 30th, 2024, the complainant submitted the complaint on behalf of her daughter and son-in-law stating that they were tenants who signed a lease with the respondent acting as their property manager. The complainant alleges the respondent is performing activities that require a real estate license and that the respondent has failed to return the tenant's security deposit of $2,000 and pet deposit of $500. The records provided by the complainant appear to indicate that the respondent is performing activities that require a real estate license. The respondent did not provide a written response or documents requested during the investigation. Possible violations include 12-10-202, license required. And again, recommended disciplinary action includes injunction and referral to criminal law enforcement.
I'll just go straight into a motion. Motion to accept staff recommendation.
Second.
Second.
Okay, all those in favor?
Aye.
Aye. I'm missing a couple.
Aye.
Any opposed? Okay, motion passes.
The next is matter L, complaint number 2025-820. The respondent pled guilty to a felony for assault in the second degree on May 1st, 2025. He was sentenced to 2 years supervised probation, education, community service, and court fines and fees in the amount of $1,658.50. That has been paid in full. Restitution was also ordered. The amount has not yet been determined. Possible violations include 12-10-217-1N, conviction, plea to specified crimes. Disciplinary recommendations are diversion,
and a fine of $250. And Investigator Gabarty can answer any questions.
Hey, any discussion?
The only comment I have is the same as we had on the earlier case that was similar, where this individual is on active probation. Sounds like it's 2 years, and this just occurred, in May. So I would just suggest that we run it concurrent, probation concurrent.
You want to make a motion? Or Erica, did you have another question?
No, I just agree with Erica.
Yeah. Okay.
Motion to accept staff recommendation with the following amendment, that under disciplinary recommendation, we add concurrent probation.
Okay, do we have a second?
Second.
Okay, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
The next is matter M, complaint number 2024-1209. The complainant filed a complaint against his listing broker, the respondent, alleging that the respondent did not provide the proper contracts and receipts in accordance with the reimbursements listed on the settlement statement, did not refund him the money he collected from a contractor, signed a contract with a contractor for work on his property without his authorization, and threatened to put a lien on the property if he was not reimbursed at closing. The investigation found additional possible violations related to brokerage relationships and accounting of money belonging to others. Possible violations include 1210-217-1M, violation of any commission rule or Part 4, 1210-217-1G, failure to timely place deposit funds, 1210-217-1H, failure to account for funds received, 1210-217-1I, converting, diverting, commingling funds, 1210-217-1Q, unworthy and incompetent practice, Rule 5.11, money belonging to others must be deposited in trust or escrow, Rule 5.14, record keeping requirements, Rule 6.22B, prohibited remedies for compensation. Oh, and statute 1210-404, single agent engaged by seller or landlord. Disciplinary recommendations are a final agency order, a fine of $3,000, coursework in trust accounts, coursework in legal issues. And Investigator Peters is available to answer any questions.
On this one, I definitely acknowledge that there were violations. I kind of struggled with the conversation that the seller expected the agent to pay the invoice. I just felt like some of that just didn't make sense to me. And I'm not sure how much weight that, how much weight was put on that in regard to like the fine. I do agree that like in regard to taking the money, he should not have accepted the money from the contractor. He should not have put that in his account and paid other people. So I do think like the violations are legitimate. I just kind of struggle with the belief that the seller had that he would pay that bill. I don't know. It just seemed like a convenient a convenient thing to say, if that makes sense.
And we did base the fines on just the amount of violations.
Okay. Yeah. That was really the only thing I struggled with. I just, had a hard time wrapping my mind around the fact that a seller would think someone would pay almost $5,000 on their behalf just because. That just doesn't track. But other than that, yeah, if the fine wasn't based on that particular factor, then I'm in agreement.
So, I had a question on that last violation. I guess I'm not quite following the 12-10-404 violation. Could you explain to me what that means? I'm missing something.
Yeah, he was working as a seller's agent, so it's expected that he works on the seller's behalf. I think part of that was, he threatened to place a lien on the property. He had fiduciary duties owed to the seller.
So is that what that means? Because I'm just not following single agent.
His
engaged by
brokerage relationships, yeah. His brokerage duties to the seller as a seller's agent.
just dealing with the fiduciary duties? Is that what you're saying?
He was representing him as a seller's agent,
Right.
and so he had specific duties owed to the seller. And it appeared that he was maybe working on his own behalf in certain circumstances.
Thank you for that explanation. I didn't see that when reading it. I felt like there were some bad moves made by this individual, but I think that that individual was trying to assist in getting repairs done and making the property more marketable. I think that there was an intent um, to benefit the seller. I think where it went wrong is when they have this disagreement about who is paying the bill. And that's kind of where it went wrong, where now that individual who paid money out of his pocket is saying that, they're going to place a lien on the property. And reality is that individual should have just had something in writing and avoided this whole thing. But I don't know that I agree with this, that he didn't perform his fiduciary duties.
I think we were mostly looking at when it came to him not being reimbursed, and he threatened his own seller with putting a lien on the property. He didn't protect the money by being in a trust account and those types of things.
Yeah. Commissioners, and if I may, maybe reading the language, specific language will be helpful for your discussion. The language of 404 is to promote the interest of the seller or landlord with the utmost good faith, loyalty, and fidelity, including, and then there is a non-inclusive list, non-exhaustive list, so to speak. So if that's helpful for your consideration.
I was going through my notes on this one, and I really think that the seller relied heavily on the listing agent, and that listing agent, he worked really hard. He went above and beyond in many respects for this seller. The seller was not around, and neither was his power of attorney. They asked a lot more of this licensee than would be typical, and he agreed to assist, and probably shouldn't have, on a lot of these things that they wanted him to do. I too wondered why the respondent would agree to pay thousands of dollars and not be reimbursed. That made no sense to me. The seller made statements that the respondent should pay him back for the property taxes and HOA dues because it took longer while it was off market for repairs that the seller wanted done. The other thing, the respondent advised the seller not to continue to pay that first contractor those additional funds, and the seller was irritated after he went ahead and paid them. So, if the seller had listened to the respondent's advice on that, not to make that second payment, that issue of that $1,000 not being put into the trust account wouldn't be an issue today. That being said, if a licensee is going to do those things, they've got to do them correctly. So unfortunately, the money received back in cash and not put into that trust account, that's the problem. Also, the respondent cannot file a lien or even threaten to file a lien on a property. I don't agree with that limitation because of issues where sellers do legitimately owe money to licensees for situations like this where they may have been taken advantage of, but it exists. I would actually, on this, because of the situation there, I would change this from an FAO to a diversion, but I would keep the coursework and the fine.
I agree with a lot of that too, that you're saying. The only thing that I would say is regarding the lien, I do feel that licensees shouldn't be threatening that unless they have taken, they've taken proper steps, right? So, for example, if you've paid money on behalf of a client, you take them to court, right? Maybe small claims court, get a judgment, and then now you can file that lien properly, right? Because obviously we don't want licensees just slapping liens on people's property for compensation or repairs. That's the only part, but I agree. I felt like this individual did genuinely try to help the seller, and as you said, Erica did a lot. He just did a lot the wrong way, though. But I would be open to that if the rest of the commissioners are open with with instead of a final agency, a diversion.
I would agree with that too.
Autumn, how about you?
I will agree.
Okay, does someone want to make a motion then?
Oh, and I'm sorry, one more thing.
Oh.
I would remove the statute 1210-404, the single agent engaged by seller, because I do think that throughout the majority of that transaction, he was, doing his fiduciary duty.
I agree.
Okay, so this is going to be a long motion. Okay, motion to accept staff recommendation with the following adjustments. Changing the disciplinary recommendation from final agency order to diversion, and removing the statute violation 1210-404.
Okay, is there a second?
Second.
All those in favor?
Aye.
Aye.
Aye, where's Autumn?
I said aye.
Okay, sorry. Okay, any opposed? All right, motion passes.
The next is matter N, complaint number 2024-1307. The complainant alleged that a $15,000 payment was made that the complainant referred to as earnest money. When her offer on a property was not accepted, the payment was not returned to the complainant. The investigation found that the $15,000 payment was made payable to the respondent and deposited into her personal checking account. Possible violations include 1210-217-1M, violation of any commission rule or part 4, 1210-217-1I, converting, diverting, commingling funds, 1210-217-1Q, unworthy and incompetent practice, 1210-217-1H, failure to account for funds received, Rule 5.14, record keeping requirements, 5.6, trust or escrow funds must be available immediately, 5.10, commingling prohibited, and Rule 5.12, earnest money procedures, Rule 5.11, money belonging to others for deposit by a broker for non-real estate brokerage services, and Rule 6.5, brokerage relationships disclosure in writing. Disciplinary recommendations are a final agency order, a fine of $5,000, coursework in brokerage relationships, coursework in trust accounts, coursework in legal issues, and a high level of supervision for 2 years. And Investigator Peters can answer any questions that you may have.
I thought the discipline was appropriate. They kind of touched on what I thought was important, which is, the high level of supervision, definitely the coursework. What I recall in this case is this was like the respondent's first real estate transaction that they so but I think that they have been licensed for a while. I want to say they have been licensed for maybe 4 years or something like that. But this was actually the first completed transaction. So I don't know. I mean, definitely, putting someone's money in your personal account is not okay. So the only thing that I kind of wondered is like final agency order versus diversion, because that person, this is their first transaction, but definitely would welcome any feedback. I'm kind of okay with it the way that it is too, so. Any other thoughts? What did you guys think when you looked at this case?
I didn't realize it was his first transaction, so but licensed for 4 years.
Agree with you, Erica.
Problem is that the fiance is involved and what they are trying to do, and I don't know that they totally explained it to the complainant. And as far as the whole 15,000 and whether it's earnest money, whether it was paying for part of the fees for the program, it was a mess, I thought. Total mess on how it was handled. And so I thought there, even though your first transaction, you've got your license, you've been through training, you've gone through things, training every year. If you've had it for 4 years, I don't remember, you've had things, so you should know better on a lot of these issues. So to say, oh, it's just my first transaction, I don't think is an excuse based on what was going on and what they were trying to do.
Yeah, yeah, it was definitely a mess. And I do think maybe and this is where it's too bad, because I think if she had her license for, let's say, 2 years, then I would be looking at the employing broker saying, hey, where's it, where's the oversight? There still should have been oversight considering this was her first transaction. So I guess I'm struggling with that too, a little bit. It's like, where's the oversight? She is completely confused on how this process works, right? So I don't know.
Did she ever get any money back? Did anything ever happen? Do we know if she ever got anything back?
The report said that she did not get the money back.
But I mean, after the fact,
after the fact.
Do we know after the investigation, I don't know if there's been any follow-up, if we know if she ever got any money back.
The last I heard, Commissioner Land, was that she did not receive any kind of a refund. She did not get any money back. In speaking to the fiance, he said that the money was non-refundable.
And they never found an investor contract of any sort, right? It was, oh, we did it online, we don't have a copy, which is really strange too. It makes me wonder if this actually happened. There's no proof that anything actually happened. So did they just take her money? We don't have any backup that the money went to anybody because it went into her account. It just a lot of red flags for me on this one.
Was there mention, and this is to the investigators, was there mention of that? Like and I just can't remember, obviously, all of the files that we've reviewed, but I can't remember if there was a mention, if there was proof in the bank statements or anything that the money went somewhere.
Yes, Commissioner Sanders, there were withdrawals in the amount of $20,000 total that went to the investment programs. However, there was a $10,000 wire transfer that remains unverified.
Okay.
So I actually thought it might make sense to increase the fine on this. I just thought this was a really ostentatious, bad transaction, but I guess I wasn't thinking about it being her first deal, but it was just bad all the way around.
Yeah, and the other thing that I do recall right now, I'm thinking about it, there was a lot of confusion created with that client because this individual mentioned in a text message that they got the house.
Right.
And they didn't really get the house. There was a verbal conversation, but it was not solidified in writing, so there was no offer accepted. But the communication was, hey, like something to the effect of, hey, they accepted our offer.
Right.
Which did give the impression that an offer was accepted. So that could have easily caused a confusion with that particular client thinking, oh, okay, so I'm turning in earnest money. And what I also recall is it was that individual's first purchase. They ended up subsequently buying a home through the same person, I think maybe before the complaint happened. So they ended up buying an actual home to reside in, but this actually took place prior to that. So that person was very green as well. They had never purchased a home, so they wouldn't probably know the process and how things work.
Okay, so do you want to make a motion or anyone else have any questions?
Yeah, and after we've talked through it, to be honest, I think final agency order, that was just my thing, like it's final agency order versus diversion. But at this point, talking through it, remembering some of the key points, I think final agency order is definitely acceptable.
Okay, do you want to make a motion?
Yeah. Motion to accept staff recommendation.
Do we have a second?
I'll second.
All right, all those in favor?
Aye.
Approved.
Aye.
Anyone opposed? Okay, motion passes.
Right, investigative matter O is complaint number 2024-1483. The complainant was the buyer of a property the respondent listed. The complainant alleged that the soil treatment area of the septic system failed prior to closing. The respondent acknowledged that at the time of closing, he was aware of a county requirement that called for a transfer of title inspection and the need for an acceptable document prior to closing a real estate sale. However, he did not ensure that the necessary steps were taken. As closing proceeded, the respondent did not discuss with the buyer or buyer's agent that the county had the transfer of title requirement, which would not be completed. After closing, the complainant needed approximately $32,000 worth of repairs on the septic system in order to live in the home. And the complainant alleged that had the proper inspections been done prior to closing, the septic system defects would have been discovered before she closed. Possible violations are 1210-217-1Q, 1210-404-3A, 1210-217-1M, 1210-404-1B, Rule 6.2. Disciplinary recommendation is a diversion, a fine of $2,500, and coursework in rural property transaction. And Investigator Hardy is here to answer any questions you might have.
So is there really a course in rural property transactions? Does that exist?
Yes, there is one.
Okay.
My thought on that is if we're requiring a course on that, they're kind of practicing outside of their expertise. Like, I would think I don't know if they'll look at another rural property, but I mean, I don't buy and sell property, but my thought is when I tell people to find a realtor, make sure that they get one that's, if they're looking at land, to find an agent that knows that and knows it well, because it's going to be different than buying a condo downtown. I definitely think some classes need to be taken. The loss to the homeowners a lot. So I definitely think the fine should reflect that.
What do you think the fine should be?
On something like that, that's not taking care of, like, I still say, like, practicing outside of an expertise, like that they don't know it, I would put the fine at $5,000. It's costing the buyer, what was it, $30,000?
32. Yep.
$32,000. Yeah.
Well, the biggest thing is that we've got a failure to disclose an adverse material fact that was known and not disclosed. And because of that, we have a huge harm to a consumer. So I think the fine is warranted at 5,000 as well.
I agree with that too.
So
I was just thinking there needed to be more coursework, but I just couldn't think of any courses. But maybe ethics, like if they were aware of these things, which they were based on the report and all of the evidence, I think we need to add a little bit more coursework.
I agree. I think that's a good idea. Ethics, okay. Anybody else?
So I just want to go back in here though. In listening to the audio file of the septic treatment person, let me go back in here, or the inspector, the respondent did not receive that actual report. So, and you had to kind of listen and go through that, but he admitted that he had not sent it to the respondent. And the complainant had called him after the fact and asked him for a copy of that report. And he said he didn't have one because he had never gone back and done the actual inspection. So when he had gotten there, he had, it was pouring rain. It had been flooded out. Everything he said, he had to do the septic pumping. But he couldn't do the testing of the leach field at that time because there's too much water to do that. And they'd asked if they wanted to come back. So they had rescheduled to do this. When you listen to the audio file, it took a little while to get through that, but the guy that was the inspector, it was after the fact that the complainant said, "Can you write this down?" basically, and he wrote up the report after the fact to tell her, well, this is what I saw at that moment, but it's not an official report. So the respondent never actually had a report that he could have given prior to closing. So that's something to keep in mind. And then it sounds like that's what we had to take a look at. We have it in writing where it says STA fell at that point, but that they hadn't had that there for him to actually disclose. He had rescheduled that inspection for later. So I do want to keep that in mind that he didn't actually have that report, didn't come from him. He hadn't received it. He hadn't been given that.
But I thought he was told. I have notes down that he told the respondent that it failed.
So I can speak to that if it's helpful. When we are charging the failure to disclose, we're not charging the failure to disclose the failure of the treatment system, because I agree there are a lot of things happening there with the weather. And, I don't think that we had evidence that he had absolute knowledge that it failed. What we're charging is that the respondent stated he knew that this transfer was needed from this transfer inspection was needed from the county, and just let the closing proceed without disclosing that. So we're saying that's an adverse material fact, that this was needed, was not completed, and that was not disclosed. So that's why that one's being charged.
And that is really an important point, because if we're focusing on a failure of a septic tank, he did not have knowledge of that because the investigation had not been done on that yet. That had been moved forward. So ideally, and what 100% should have happened is they should have waited and postponed the closing until after confirmation one way or the other on that, because that is a big ticket item. They're at the mercy of the weather on some of those. My question is, the buyer's agent, there was no communication between the buyer's agent and the listing agent on that. Both of them should have been aware that that was necessary then. And as to, Bernadette, I think you've got a really good point as to practicing out of your area, but he had, on behalf of the seller, requested the inspection, rescheduled the inspection so it could be done at an appropriate time when they could find out whether it did or did not work. The communication was not there that I can see anywhere between the buyer's agent or the seller's agent to get that done and locked in place prior to. It seems like there was some confusion that the title company would take care of that, which according to our documentation, they don't have to do that. And so I'm just concerned that this falls, where that falls on this one, that there's a county requirement that has to be done. And that there was no communication between the buyer's agent and the listing agent, and they were well past the inspection deadlines on this. Like, where was that supposed to fall within the contractual deadlines that this was taken care of? Is it truly right at the closing table that has to land?
I was just going to say that the buyer's agent is a separate investigation. So we are looking into that side as well.
Well, and I just kind of come back to the point of this is why you want to kind of follow protocol in these types of situations, because it was mentioned in the report that the listing agent assumed because it was a newer septic system that there wouldn't be anything wrong with it. And I think based on that assumption, there is a little bit of lackadaisicalness, if that's a word, in regard to getting the proper paperwork, the proper inspections from the county, which resulted in this case in a really big issue. And so, I think this individual kind of gambled a little bit that, oh, this is going to be okay. And in the end, it wasn't. And $32,000 later, that's a big deal. So I still think that the 5,000 is appropriate. It's a diversion, not, final agency. I think, when you are practicing, I don't know that this individual is completely incompetent. I mean, he knew what to do. I don't even know if it was that he didn't know. I just think that there wasn't enough action on his part to do what needed to be done. And that should have started at the beginning of the process. So when they got that contract in, those steps are normally taken then. And I think because it was a newer system, there was an assumption that everything was going to be fine.
And I agree with you on that. I agree that the fine should be hefty. Diversion is fine. Coursework is fine. But I do have, with no mention in their contract in that area of this being a requirement, where does it come up that the responsibility, I mean, it's just kind of this unknown that if you're in that area, you have to know that that is coming. And so it is kind of interesting to me. I mean, he knew it was moving through the process, but I am curious about that buyer's agent. Communication had to happen. This either had to, in my mind, if I look at the contract, this should have happened before the inspection deadlines. And or a failure had to have been noticed, under the actual septic system prior to closing. And with an extension, that should have been communicated to it. So, but I did want to at least make known that he did not get a report of failure.
Yeah.
Okay, so Erica, do you want to make a motion?
Which Erica?
Either
one. So I motion to approve the staff recommendation with the adjustment that the fine be increased to $5,000 and there be an additional requirement for ethics coursework.
Okay, is there a second?
Can we also add that rule education?
It's on there already.
Oh, okay.
Yep.
Yeah, it is. Yeah.
Somebody want a second?
I'll second.
Okay. All right. All those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes.
All right. Investigative matter P is complaint number 2024-1365. A complaint received by the Division of Real Estate, excuse me, alleged that the respondent held the complainant's earnest money in an account that was not an escrow account. The respondent and complainant were both parties to the transaction. The respondent confirmed that he deposited the earnest money into his own business account and confirmed that the account was not an escrow account. Possible violations are 1210-217-1M, 1210-217-1H, and Rule 5.11. Disciplinary recommendation is a diversion, a fine of $2,000, and coursework in trust accounts. Investigator Hardy is here to answer any questions you may have.
Does anybody have any discussion or questions?
I thought the recommendation was reasonable.
Agreed.
Agreed.
Agree.
Okay, someone want to make a motion?
Motion to accept staff recommendations.
A second, anyone?
Second.
Second.
Okay, all those in favor?
Aye.
Aye.
Any opposed? All right, motion passes.
Investigative matter Q is complaint number 2024-2299. Complainant explained that he entered into a purchase contract for a property listed by respondent. Complainant paid an earnest money deposit in the amount of $2,000. When the appraisal came in low, the complainant timely terminated the contract, and the parties did not agree to a purchase price reduction. Complainant alleged that respondent refused to release his $2,000 earnest money deposit, which affected his ability to purchase a different property. Complainant also alleged that respondent failed to disclose her ownership interest in the subject property and failed to disclose that the seller is her son. The investigation also noted the potential violations that respondent failed to ensure that the real estate transaction documents accurately named the seller of the subject property. Possible violations are 1210-217-1M, 1210-217-1Q, 1210-217-1H, 1210-217-1I, and Rule 6.17. Excuse me, I apologize. Disciplinary recommendation is final agency order, public censure, a fine of $5,000, coursework in contracts, and a direct referral to the Office of the Attorney General. And Investigator Davies Wright is here to answer any questions you may have.
I don't have any questions, and I agree with the proposed discipline.
Agree.
Agreed.
I agree as well.
Okay, someone want to make a motion?
Motion to accept staff's recommendation.
Second, anyone?
Second.
Okay, all those in favor?
Aye.
Aye.
Any opposed? Oh, all right, motion passes.
All right, commission matter R is complaint number 2025-609. On July 22nd, 2024, the respondent entered into a guilty plea for menacing, a class 1 misdemeanor. The respondent received a deferred judgment and sentence and was ordered to serve 12 months of unsupervised probation. The respondent was also ordered to complete a substance abuse evaluation and a parenting evaluation and to comply with recommendations. The charges in the resulting guilty plea are from a June 23rd, 2024 incident in which a verbal altercation between the respondent and her granddaughter escalated between the two. The respondent has complied with the conditions of the probation and the deferred judgment and sentence, including paying all court costs. The case is scheduled for review on August 6, 2025. Possible violations are 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Disciplinary recommendation is diversion and a fine of $500. And Investigator Coates is here to answer any questions you may have.
I just have a real quick, simple question. That last sentence, the case is scheduled for review August 6th. I'm assuming that that is the criminal case or,
Yeah,
okay,
yeah. I'm sorry.
okay.
And I double checked on that this morning, and that is still the case. There was some indication that she might finish the probation early, but
Okay.
as far as the court records are concerned, it's still scheduled for the August review.
And so, and I may have missed this in my note taking. Is she still on probation then until August? Is that what that means? And I may have
Well,
just missed that.
It's a year probation,
Okay.
so
From,
we need to add the concurrent.
okay. Thank you. For some reason, I didn't notate that, so I thought she was done with her probation. All right, well, motion to accept staff recommendation with the addition of concurrent probation as a disciplinary recommendation.
Okay, do we have a second?
Second.
All right, all those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Hello again, commissioners. This is complaint matter S, and that's number 2024-2310. The complainant alleged the respondent failed to disclose a known gas leak when she sold her property to the complainant. It appears that the basement oven had been disconnected prior to the property inspection and the appraisal. The respondent indicated that the oven had been disconnected because the finished basement had not been permitted and it might have been called out on the appraisal. The respondent did acknowledge that there had been an issue with the oven and that she had a vendor come to the house who found an issue and provided an $800 bid that included installing a replacement part. However, instead of having the part replaced, the respondent said her husband completed the repair by tightening a few wires. Despite the repair having been made the same month as the buyer's inspection was done, it was not included on her seller's property disclosure. Possible violations include 1210-217-1M, 1210-217-1Q, and 1210-404-3A. And disciplinary recommendations include diversion, a fine of $2,000, and Investigator Walker is here to answer your questions. But I also wanted to point out that Investigator Walker had a follow-up conversation very recently with the respondent's husband that went into a little bit more detail about the repairs that he performed. And I'll turn that over to Investigator Walker to expand on. Are you there, Investigator Walker? Okay.
Yeah, I followed up with the respondent's husband. They were the homeowners. He indicated that he had like 30 years in the construction and home improvement industry, and that kind of qualified him to fix the gas stove. He indicated that it was just kind of like a loose fitting rather than needing any sort of new part.
Was the husband licensed through a mechanical mechanism through the city or state?
Not that I'm aware of, and they have also relocated down to Florida as well.
So my thought process on this is, I do think that the listing agent, or was it the seller? Yeah, the listing agent, probably thought it was resolved. So I don't know if there was an intentional non-disclosure. However, probably should have taken the additional step to ensure that that leak no longer existed by testing or something, right? Bringing in, if her husband was in the industry, you would think that maybe he'd have the tools to also test for the gas leak, which he must not have. So, that I still think that responsibility does fall on the seller and listing side to ensure that that repair is done. Any thoughts? Should I motion? Okay, motion to accept staff recommendation.
Second.
Okay. All those for the matter?
Aye.
Aye. Any opposed? All right, motion passes.
All right, and now complaint matter T, which is number 2025205. The Appraisal Subcommittee's National Registry indicates that the respondent's Florida appraiser credential was revoked in August of 2024. The division has no record of the respondent reporting the discipline to CREC. An agency order from the Florida Appraisal Board dated August 9th, 2024, entered a voluntary relinquishment for permanent revocation. The respondent was not present. The respondent claimed to have no knowledge of having to report any discipline from any other jurisdiction to the Colorado Real Estate Commission or the Colorado Division of Real Estate. The Florida revocation was initiated as a result of previous discipline from the Colorado Board of Real Estate Appraisers. Possible violation includes 1210-217-1M and Rule 6.23. And we do not have any disciplinary recommendation. And speaking to that just a little bit, we've had these cases before in the past where there is kind of a chain reaction of discipline that occurs after Colorado has initiated discipline. And we've attempted to close that loop in a variety of different manners in the past. In this particular case, we're bringing this to the commission to determine what the appropriate discipline would be, with the consideration that this licensee is an employing broker. They're an ER, so they have the ability to hire associate brokers. They currently do not. But in that capacity, they would be responsible for ensuring compliance with all regulations. And this and the previous discipline that you see might suggest an ongoing pattern of not complying with regulations or not even being aware of those regulations. So with that, we present it to you for your discussion and recommendation.
I feel like if he's an employing broker, even if he doesn't have anybody underneath him, with the history, that's not something I would want him to keep doing or have the ability to do if he doesn't follow the regulations on his own. How can we think that he's going to expect that from somebody that he employs?
My thought, my notes on this, although I didn't look at it from the perspective of an employing broker, was what we typically have seen in these cases, which is a diversion and a $500 fine. However, if this is a pattern, then maybe that fine should be a little bit higher. But I also understand, like, this is the whole cycle. So it's like you get disciplined here, and then you get disciplined in another place where you have license, and then you get disciplined here, and then probably another place. It's just like this cycle of discipline and stuff. So, but I don't know. I think diversion, and I think somewhere between a $500 to $1,000 fine. That's just my thought process.
That's what I had written down. Actually, yeah, I have diversion and I had a $250 fine, but I'm okay with 500.
I'm fine with that.
Okay, can we get a motion?
This one's going to be a little bit different because we are not approving staff recommendation. Motion to impose the following discipline: diversion and a $500 fine.
Okay, a second.
I'll second.
All those approving the motion?
Aye.
Any opposed? Okay, motion passes.
All right. Your next, and I believe last, investigative matter is investigative matter U. This is complaint number 2024-1614. On September 11, 2024, the division received a complaint from the complainant stating that he hired the respondent and her brokerage firm to manage his rental property in Fruita, Colorado. The complaint alleges that the respondent failed to remit rental proceeds for the past 6 months and has failed to respond to the complainant's communication attempts. The investigation noted the complainant has since terminated management services with the respondent. The respondent didn't respond to the complaint. Subpoena bank records show that the tenant's rental proceeds were made to the respondent with only one payment made to the owner. Bank documents show that the respondent used 2 bank accounts to hold rental income and commingled funds amongst 4 other accounts. The respondent failed to hold trust funds and trust accounts or label the accounts holding funds of others. It also appears that the respondent allowed her unlicensed husband to perform real estate activities. It appears that the respondent owes the complainant approximately $19,975 in rental proceeds. The bank records also show that the respondent used approximately $34,439.16 of trust funds for personal expenditures. The bank accounts have been closed by the respondent. It is unclear where the money was transferred to. It also doesn't appear that the respondent had a designated account for holding security deposits, as those funds appear to have been commingled with rents. The respondent currently has 4 other open investigations with similar allegations. The respondent's website shows 2 active sales listings in the Grand Junction area. Possible violations include 12-10-2171H, 12-10-2171I, 12-10-2171M, 12-10-2171Q, 12-10-2171W. Possible rule violations include 5.2, 5.5, 5.9, 5.10, 5.15, 6.3, 6.25, and 7.1. Recommended disciplinary action includes final agency order, public censure, revocation, $30,000 fine, and also revocation of the brokerage firm license and refer the respondent to criminal law enforcement. And myself and investigator Marcy Rivera can answer any questions you may have.
The only question I had, and I thought all of this was very sufficient based on the case. The only thing I wondered about, though, under the statutes, I thought we could only do $2,500 per violation. How does that work? I just don't want it to come back to us. I love the fact that it's a $27,000 fine, but are we able to do that?
Yes. So typically when we, for revocations, we issue max fines with those, and I believe we calculated it correctly. So if we did not, my apologies on that.
Now, Erica, you have to add the bottom ones too.
Yeah.
The 6.3.
Yeah, I did 7 times. It's 2,500, right?
No. You've got 10 up top though. You have 10 plus 3 is 14.
Oh, I missed. Okay, I see.
Yeah.
Okay, so it's 2,500 per. I thought rules we couldn't do or something like that.
Commissioners, if I may, it's 12 violations. So the fine that Mr. Rose read, $30,000, is accurate multiplication, 12 times 2,500.
Okay.
That's what I have. And we don't fine for the 12-10-2171M.
Okay. And then so on the paper it says 27.5. So can we just increase that to the 30?
Yeah, so my apologies that there was a more updated version that should have been relayed to you with $30,000 fine.
Well, that being said, if none of my commissioner counterparts have any comments or questions, I'm happy to do a motion. Motion to accept the staff recommendation.
We have a second?
Second.
Second, yeah.
Okay, all those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes.
And Commissioner, is it okay to do like a 5-minute break?
Yes, it is now 12:05, so, but if we return at 12:10.
Okay. Thank you.
Okay, it looks like everyone is back. So now we'll move on to licensing matters. And we'll start with licensing matter A.
Matter A is complaint number 2025-534, and this is a preliminary advisory opinion. On November 12th, 2015, the applicant entered into a letter of acceptance with FINRA. The letter ordered a 30-day suspension of the applicant's FINRA registration and a $30,000 fine. The suspension was completed and the fine was paid on November 18th of 2015. This matter was disclosed on the application, and as usual, we do not have a recommendation. And Investigator Martinez can help answer any questions.
Okay, is there any discussion on this matter?
I kind of jotted some notes on most of these where, I kind of jotted down like pros and cons. But this is what I just didn't kind of have a recommendation. So, but the pros I wrote, there's been 10 years since the incident. It was a different profession than he resided in. And then obviously having his license gives him an opportunity to make a living. The cons I have is that in reading the materials, I felt like he didn't really take responsibility. There's definitely some ethical issues. Disappointed that there were no recommendation letters that were provided. And not all of the requested information was originally provided. I think subsequently it was, but it wasn't initially provided. So that was a little concerning too. That there's very clear list of things that needed to be turned in, and those things weren't originally turned in, but eventually they got it all.
I don't know. I don't think there was employment history either, or letters of recommendation, et cetera.
Yeah.
So they were missing some things.
I know that this is kind of a sensitive thing in terms of like how we can move forward, and so I didn't jot down a recommendation, so I don't know what we do here.
So how does that work? I know I jotted a note to myself of that there's no employing broker. There was no letters of recommendation, no employment history. Like we don't have a lot of information about what he's been doing.
Yeah.
Yes.
But he paid all of his fines. It's been 10 years. There's no other offenses. It was a FINRA offense, so
My concern is like I know with the convictions that are a certain timeline, we have to be careful how we respond to that. But to be honest, in the moment, I just can't remember all the rules of that.
This is a preliminary advisory opinion, not a license
Oh, okay.
application.
Right. So
Gotcha.
when he submits the application, he'll probably provide an employing broker letter.
Okay.
In history. Yeah.
Okay. Got it.
are there rules that we're supposed to or regulations that we're supposed to take into consideration on this since I'm new?
Irina, you might be able to speak to that better.
Yeah, I don't know. Yeah, I was going to ask Irina.
Yes, absolutely. Commissioner Bugarin, in this portion of the meeting, your job as a commission is slightly different. Where before we were looking at violations and charges, here you are assessing the application package. In this specific case, it's not even an application, but preliminary advisory opinion. You assessing it, and then as a group, you have to decide whether you will issue positive or negative opinion based on information in front of you. So your role is slightly different. And in this process, you are guided by there is legislative change into how we're supposed to look at criminal convictions. That's where I think Commissioner Sanders was referring to. And that is some convictions that are over 3 years old, considered to be stale and therefore are given less weight. So if you need more guidance on that, I'm happy to add this to our topic for executive session and kind of refresh everyone's recollection on that statutory framework for criminal conviction assessment. or if it's not needed, we can continue moving forward with the process as is.
So the three years obviously is met. However, the relevancy is my concern, because the relevancy, the person was in the financial industry and was being regulated, was licensed, and had an issue. So because of that, I would vote for a negative preliminary advisory opinion because of the relevance to our current industry.
Yeah, I mean, I was definitely wanting to lean towards that. I just didn't know what our parameters were around that. And then my understanding, and correct me if I'm wrong, is this is just a preliminary opinion. So this individual can still apply, and then it will come before us again to make a decision. And then, okay. Well, I will agree with you, Renee.
And if I may refresh everyone's recollection, so it sounds that Commissioner Line is talking about directly related prong, and Commissioner Line analyzes it as it is directly related to our profession. And then the next step is for the commission to, if you find that it is directly related, then there is a last part of your analysis is two-prong. You have to analyze whether the person has been rehabilitated and whether this person is able to perform safely the duties of our profession. So
I would say we don't have any evidence of those things. We were not provided enough information to make a decision to determine if the person is rehabilitated. So because of the lack of information, I still would vote for a negative preliminary opinion.
I agree with that.
I would say let him apply and give us all the information. I don't want to make a decision on somebody without having all of the
Yeah, this is just an opinion.
I would say let him apply.
Well, okay, but we have to give an opinion, either positive or negative for right now. So
and my understanding is positive would be full approval.
No, it is not. It is just an opinion.
Okay.
So we are just giving our opinion at this point. We are not ruling on license stuff.
But procedurally, if you give a positive opinion and then the person goes on to apply, if there's no new information for you to consider or negative information, then it would just get issued. So if you feel like there isn't enough information here and you do a negative opinion, then they do have the ability to apply. I generally talk to these folks. One of the first things I encourage them to do is to listen to the meeting recording so they can understand your position and the kind of information that you're looking for. Hopefully that helps a little bit.
Yeah, thanks, Penny.
Yeah, thank you.
Okay, does someone want to make a motion?
I wouldn't mind making a motion. I'm just trying to make it properly. Motion to
grant a negative.
Thank you. Thank you. Bear with me. Bear with me. Yes. And so motion to grant
issue a negative
issue. Thank you. Thank you. Okay. Motion to issue a denial, negative opinion. Did I do that right?
Yeah.
Okay.
Okay. So we have a motion. Anyone want a second?
I'll second.
Okay, thanks, Autumn. Okay. All those in favor?
Aye.
Aye.
Aye. Anyone opposed? Okay, motion passes.
All right, licensing matter B, is an application. It's complaint number 2025-188. In June of 2024, the applicant was convicted of larceny of military property valued at more than $1,000, violation of Article 121, federal conviction. The applicant was sentenced to 60 days confinement. The case is closed. Applicant previously received a negative preliminary advisory opinion at the February 2025 Colorado Real Estate Commission meeting. This application includes an additional new letter from the applicant and his employing broker. As usual, there's no recommendation. And excuse me, Investigator Quintana is here to answer any questions you may have.
I would say that I really appreciate the updated letter and information that was provided. It sheds some more light on the situation and on the applicant. I would actually vote for an approval on this applicant.
I agree. My notes were that I think in the previous meeting, just that point that we didn't have enough information. I know we were really focused on the fact that it was a very recent charge, but really in going through everything, particularly the new information, I came to the same conclusion that I think that this person has been rehabilitated, even though it was recent. I think that they have demonstrated that they, could enter into this profession ethically. And I think that that individual really learned a valuable lesson. And so I don't have any.
I appreciated all the letters of recommendation that he had in there. It looked like he was rehabilitated. I don't really have any concerns that he would do anything unethical. I would say it's a positive.
Any other discussion or questions? Okay, someone want to make a motion?
If I can get it right this time, motion to full approval and positive opinion.
No, we're motioning for an approval of the application.
Approval, okay. This is like the first day I've motioned on these, so
I was doing it.
So motion for approval of the application.
Yep. All right. Do we have a second?
Okay.
Second.
Okay. All right. All those in favor?
Aye.
Aye.
Okay. Any opposed? Okay. Motion passes.
All right, licensing matter C is complaint number 2025-307. It's a preliminary advisory opinion. On October 4th, 2024, the applicant was convicted of an unclassified possession of a large capacity magazine. The applicant was sentenced to 180 days in jail, which was suspended, 60 days in home detention, and 12 months probation, which is ongoing until October 3rd, 2025. Additionally, the applicant was sentenced to a fine of $571 with a remaining balance of $359. There's no recommendation, and Investigator Tabitha Quintana is here to answer any questions.
My notes on this one was more of a concerning route in terms of giving a positive opinion. I was more concerned about that. And so notes I took is that like this incident happened approximately 8 months ago, so it's very recent. There was a very vague explanation of the incident, so I didn't feel like I grasped what happened very well. I didn't really see any clear accountability. There were no recommendation letters. And most importantly, he's still on probation and paying fines. So I kind of noted that my vote would probably lean towards denial or negative opinion.
I agree with you, Erica. Maybe after he's served his probationary terms, then he could reapply.
Yeah.
He also didn't supply any employment history or personal statement, which doesn't give us anything to go on. So I would vote for a negative opinion.
I guess just for the record, I gonna go for a negative opinion of it. But I do feel like he's really young. There was no real like explanation of what was going on. But I also said maybe after his probation, that maybe then look at it again or apply then. But as for right now, I think you do stupid things. I've never done anything that stupid, but I don't know. We don't know if his family's military and that's why they have that. I have no idea. So I guess there's got to be more information and tell him to try to get after probation.
Okay, does anyone want to make a motion?
Motion to issue a negative opinion.
Okay, do we have a
I
second?
got it.
You need a second?
Oh, Commissioner Sanders, it's actually not a negative opinion. This is again an application, so you have to approve
denial.
or deny.
I thought this was no, it's a preliminary.
I thought this, yeah, I thought so too.
It's
It
a
is.
preliminary.
It says preliminary
It's
advisory.
preliminary. Yeah.
Oh, I got it wrong in my notes. In my notes, I have this an application, so I apologize.
Okay,
That's
yeah.
good. Right. Okay, so we have a first. Anyone have a second?
Second.
Autumn, okay. Okay, all those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes.
All right, licensing matter D is complaint number 2025-458. This is an application. On September 13th, 2013, excuse me, the applicant was convicted of a controlled substance distribute Schedule 2, a Class 3 felony. A fine of $4,636.50 is still owed. On July 14th, 2014, the applicant was convicted of a controlled substance unlawful use, a Class 2 drug misdemeanor, controlled substance in possession Schedule 1-2, a Class 4 drug felony. The fine amount of $1,493.50 is still owed. On September 5th, 2014, the applicant was convicted of a Class 1 misdemeanor violation of protection order. There is a current balance of $563.50. On September 14th, 2016, the applicant was convicted of violation protection order criminal misdemeanor. Current balance of $458.50. On July 22nd, 2019, the applicant was convicted of resisting arrest, obstructing a peace officer, and false reporting. There's a balance of $579.50. The applicant provided a letter showing his most recent tax return of $739 was applied to his court fee balances. There's no recommendation, and investigator Tabitha Tong is here to answer any questions.
My notes on this was there were a lot of pros. He appears to be rehabilitated. He got quite a few, I think 5 recommendation letters, which really spoke to, the changes he's made and his character. His potential broker has discussed, in implementing additional training and protocols. Really the only thing that I questioned, and I really don't know that we need to consider this or not, was that he had several outstanding balances. And that was really the only concern. Again, I don't know if that even needs to be considered by us. Maybe this is a Irina question, but other than that, that was really the only issue. Other than that, I thought approval would make sense.
Yeah, there are 5 outstanding balances.
Yeah.
And add it all up, they are fairly significant. It doesn't look like there's been an attempt to work and make payments. We can't tell. The letter does not really explain anything, so which was really kind of concerning. It was just kind of a general letter, and I would have preferred some more details, some more explanations, something to get behind or buy into. So I was concerned about the letter and why these things happened, and yeah, about the money that is still owing.
I had
When
this.
I spoke with him, he said he was working on getting on payment plans, and he would contact me once he got on payment plans.
Has he done that?
I believe, let me just look. I thought he sent.
I think Exhibit 26 showed a payment plan. But
Yeah, I thought there was the payment plan on there.
One noted $20 a month that was going to.
Yeah. There
Okay,
was that, but and he said he was going to contact the rest of the courts, but I haven't heard back since.
Does anyone know if these fines are never paid, for example, will that cause more court violations? Do we know? I don't know if anyone has knowledge
They
of
get sent
experience.
to collections. He said they're in collections, and then that's why they're his taxes are being taken because
Okay.
they are in collections.
So he's not at risk of any kind of charges based on not paying.
I'm not sure, but I just know that his taxes are being taken and he's going to get on payment plans. That's what he states.
$20 a month isn't much of a payment plan, in my opinion, for what the balances are. It doesn't really show an effort, and the letter, like I said, I didn't think the personal letter was not good. I don't think it's showing responsibility. It's not. I have a problem with the letter and the balances owing.
My comments that I have, it was, over 10 years ago. The applicant was very young at the time. I was very glad to read the statement that he's turned his life around, completed drug rehab, serving those in need, both here and abroad. But I do focus on the bulk of the balances that are still remaining, thousands of dollars. There wasn't a significant effort to pay those off in all that time. Some of them have gone into collections with no plan in place to repay. So, I mean, my belief is that that is part of completing your rehabilitation. That being said, I don't know that that aspect of it necessarily ties into the ability to conduct real estate business safely. So I don't know how much we can weigh that. My comment to the applicant would be, I mean, I would go ahead and issue an approval on this, but I would state, just as a comment to the applicant, pay those off. Those debts you owe as part of completing your rehabilitation that was absorbed by others to date. So that would be my.
The convictions weren't all 10 years ago. We've got convictions in 13, 14, 16,
Agreed.
19. So we've got a pattern and an ongoing issue. So.
But I don't know how much we can weigh that one aspect of that as to the safety of practicing real estate. I agree with you 100%. If that was something that we can say we can't do, I don't know. That could be a question.
Well, there is an option, and just in these conversations, I'm kind of leaning towards this. If I just don't know how to go about it, but to approve with restrictions, and maybe part of that restriction would be, something regarding making sure that this individual is, maintaining his payments. I guess the only time that we would know is if he ever got in trouble, and then now we're reviewing those things. But I would say maybe consider that. We might need a little bit of guidance though on how to, like, what we are able to restrict.
Well, if we go through, okay, it's over 3 years. So the last one is more than 3 years, so it's stale. Is it directly related? Not necessarily. I don't know. Is it directly related or not? I mean,
I would say no.
I would say no, but I'm okay. So back to that Exhibit 26, as far as the payment plans go, if you look at that, it says the monthly beginning June 1st of 2025, but projected final payment will be $3,217 due October 1st of 2025. So he
Okay.
must have a plan in place if he's planning on paying off the bulk of this in
Well,
October.
okay, but all right, but we need to follow this new thing that's put up by the state. So it is over 3 years. The question is it directly related? If the answer, if it's
I'm
not
gonna say
directly
no.
related, then we cannot deny it. It has to be directly related to what we're doing in order to move forward. Otherwise, we have to approve it.
But we can approve with a noted restriction.
Right.
So approval, positive opinion with restriction, and the restriction would be recommendation to pay off fines.
No, we can't
Would
do
show
that.
very well at the application process, or however we'd like to.
It's an application, so we have to approve or deny the application. So if it is not directly related, we cannot deny it. So if we can't deny it, then we have to approve it. So unfortunately, it looks like we have to approve this unless you can figure out a way that it is directly related. Otherwise, you have to approve. And
Well, there's
you
two
can't-
categories of approval. You have full approval, positive opinion, or you can do
No.
approval, positive opinion with restriction.
No, this is not a positive opinion. This is an application. You have to approve or deny.
But
So
what you're saying is there's an option to approve with restriction. We just need to understand what those restrictions can be.
Commissioners, would it be helpful if we will table this discussion for now and put it in an executive session?
Yes.
Okay.
okay, we're gonna table D and we will come back to that. So let's move on to E.
Okay. Licensing matter E is complaint number 2025-690. So this is an application. In March 2007, the applicant was convicted of controlled substance conspiracy to distribute, manufacture Schedule 1, a Class 3 felony. The applicant was sentenced to 2 years in the Department of Corrections, 5 years parole, and a fine of $3,347.50. The applicant has completed all terms of jail, parole, and has paid all fines in full, and the case is closed. In February of 2021, the applicant was convicted of DUI with 3+ priors, a Class 4 felony. The applicant was sentenced to 90 days in jail, 2 years probation, and a fine of $1,750. The applicant has completed the terms of jail probation and has a $0 balance. The case is closed. There's no recommendation, and Investigator Quintana is here to answer any questions.
On this one, I think that individual has been rehabilitated. They completed their terms. The broker that their potential broker, I'll say, has protocols in place to provide adequate supervision and training, and they have recommendation letters. So my opinion is to vote to approve.
I agree with that.
Agreed.
Okay, someone want to make a motion?
Motion to approve the application of licensure.
All right, do we have a second?
I'll second.
All right, all those in favor?
Aye.
Aye.
Any opposed? Motion passes.
Okay, licensing matter F is complaint number 2025-692, an application. On June 20th, 2001, the applicant was convicted of a petty theft misdemeanor. The case is closed. In July 2008, a felony forgery conviction was entered after a 2002 deferred judgment was revoked. The applicant has paid the fine in full, and the case is closed. There's no recommendation, and Investigator Quintana is here to answer any questions.
I'm kind of echoing the last one. This was a really long time ago. They appear to be rehabilitated, and either way, based on our guidance from the state, I think it would be noted that we should approve it.
Agreed.
Agreed.
Motion to approve the application for licensure.
Do we have a second?
I'll second.
All right, any opposed? Okay, motion passes.
Okay, licensing matter G is an application. It's complaint number 2025-719. On May 14th, 2009, the applicant was convicted of accessory to crime, suspect of class 1, 2, a class 5 felony. The applicant was sentenced to 4 years probation. Probation was revoked, and the applicant was resentenced to 2 years in the Department of Corrections with 459 days credit for time served. Applicant was fined $2,974 and has paid it in full. On May 13th, 2011, the applicant was convicted of drug trafficking possession with intent to distribute less than 5 grams of methamphetamine. The applicant was sentenced to 8 months in the Department of Corrections, 1 year probation, and a fine of $100. The applicant has completed all terms successfully, and the case is closed. There's no recommendation, and Investigator Quintana can answer any questions.
I looked over this. I don't know. I read all of the letters of recommendation as well, and she had letters. But I know part of the like asking for the letter of recommendation is people stating that they know what she's done and writing it, but not one of them stated that they knew what had happened. So do people know? I mean, but she's done stuff, went to school, became a paralegal. There's other stuff that's there. It was a long time ago, but I don't know if that kind of bothered me in the letters of recommendation that nobody even knew anything about it.
She had a letter of recommendation from her parole officer, which was a very good recommendation. The parole officer would know her, know what happened, and if they're not good, the parole officer will tell you.
Yeah. And I think really those letters of recommendation, the takeaway from those are what's the character of that individual now. And they definitely spoke to a rehabilitated person. It just sounds like she kind of got caught up in, a situation with an ex. And but I do think that she provided sufficient documentation to warrant an approval, a full approval.
I agree.
I would be supportive of a full approval.
Bernadette, are you okay with that?
Yeah, no, I am. I really didn't remember the letter from her parole officer. But she had other letters, so I mean she had multiple letters.
Yeah.
And she did, change, and I always try to think of that too. I mean, when you're young, do dumb stuff sometimes.
Okay, does someone want to make a motion?
Motion to approve the application for licensure.
Is there a second?
Second.
Okay. All right. All those in favor?
Aye.
Aye. Any opposed? Okay. Motion passes, and we're done with licensing matters. We don't have an ESP, so next we need to go into the AG matters, and we need to go into executive session to discuss D on the license. So
there's a topic that's going to be discussed, and I need to recuse myself from it because I know more about the case.
Okay, that's fine. Irina?
So with that being said, yes, I knew that Commissioner Bugarin having a conflict of interest with the AAG matter, so she will be recused from that. But since we adding to the executive session, the discussion, Commissioner Line, I just want to make sure that in addition to the motion that I sent you an example of, you should add that we are also going to executive session to receive legal advice on recently enacted statutory rulemaking for assessing applications that disclose criminal conviction, specifically licensing matter D 2025-458. And so because Commissioner Bugarin is not recused from that discussion, I propose that we take care of that portion of it first, and then Commissioner Bugarin will recuse herself from the executive session. And second part of the executive session, we will discuss AGO matter. Does it make sense what I'm suggesting?
It does. I'm not sure I can say all that verbiage, so I will try. I'm going to say some things, and if I'm missing it, you can tell me. Okay. All right. So this is Renee Lind, and the time is 12:48 p.m. on June 3rd, 2025. This is a meeting of the Colorado Real Estate Commission. I move the commission to convene an executive session pursuant to section 24-6-402 3A2 of the Colorado Revised Statutes for the purpose of conferring with adjudicatory counsel and receiving advice on specific legal questions and issues related to case 2023-829 and also on case 2025-458. So could someone make a motion? No. Yes, do we need a motion for that? We do.
So
Yeah.
moved. Can we say that?
Okay, so Erica,
So moved.
okay, motion. Do we need a second, anyone?
I'll second.
Okay, Autumn. All those for?
Aye.
Aye.
Aye. Any opposed? Okay, motion passes, and we will now move into executive session. Make sure you turn off your audio and your video before going into executive session, and we will discuss the 2025-458 first so that Bernadette can be there, and then she can go out before we discuss the other one. Okay. Okay, looks like everyone is back. The time is now 1:10 p.m. and we are going to go ahead and proceed with open session. We'll go back to the license matter D 2025-458. And after does anyone have any further questions on matter D, or are we ready to make a motion on license matter D?
I'm ready to make a motion.
Okay,
Motion to approve application for licensure.
do we have a second?
I'll second.
Okay, Autumn. All right, and all those in favor?
Aye.
Aye, any opposed? Okay, motion passes. All right. And now we are moving on to the AG matter. Which is someone, we need, dealing with complaint 2023-829. We had a counter offer on the table.
And
Erica?
are we ready for our motion?
Sure. Does anyone have any other questions on that?
Do I need to leave on this?
Technically, yes. I don't know that we're actually going to discuss anything. We're not really saying what we're doing, so I think you're okay to stay, Erica, if you just make your motion.
Okay. Motion to approve counter offer with the addition of new settlement parameters that were provided to the council.
Second.
Second, Erica. Okay. All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes. And we are all done unless someone has anything else.
Nope.
Okay, the time is 1:12 p.m. and we are concluding our Colorado Real Estate Commission meeting.